So for this week, we are going to discuss again issues for mains or these, okay? So why financial devolution is becoming an issue between center and states. Recently, some states have demonstrated a protest at Delhi. So we'll see what are the reasons. Then we'll look into the issue of money bill. So why I have included the issue of money bill here? In the recent context, where did we find mention about money bill? No, that we discussed already, no? In some other context, we have recently, I think less than a 10 days time only, Supreme Court has mentioned in its judgment about this money bill issue. And 7-judge bench is also going to look into this issue of money bill. In what context? Aadhaar is already there, no? Issue. Electoral bonds, good. So electoral bonds also, if you have remembered, that was introduced through Finance Act in 2017. That is also to, again, they have used the way of money bill to bypass the Rajya Sabha, right? So in this context, we are going to look into this. Supreme Court has made some harsh remarks, okay? And 7-judge bench is going to look into this repeated using of money bill route to bypass the legislative procedure. So we'll look into that. Then notable, some famous cases of Supreme Court, we'll look into some context, I'll explain that. Later, we'll discuss about the Wildlife Protection Act of 1972, why it is in news, okay? These two acts I have included because environment, in environment also legislations play an important role. Every year, 1-2 questions will come, and these are always coming in the news. So this Wildlife Protection Act, not only in the recent context which we are discussing, but also in terms of recent amendment. If you have remembered, in 2022 only there is an amendment made to 1972 Act. In that context also it is very important. Then this Forest Conservation Act. So Supreme Court has said you have to revert back to the old definition, dictionary definition of forest. There's a lot of controversy surrounding this. We'll look into this also. Then triple dip La Nina. So we'll look into what is El Nino, La Nina, what happens, and what is the impact of till now we have a you can say like we have a notion that El Nino and La Nina will influence global weather patterns only. But for the first time we identified there is a link between the La Nina and pollution in India also. So we'll understand what is the link and how it is there. And today's news is with respect to surrogacy, right? So Center has issued fresh rules with respect to surrogacy. So some amendments were made to this particular law. We'll look into this. Then rise in a dialogue. So what are the key highlights we'll look into? Then recently High Court, Manipur High Court, it made a statement that this ST tag for this mighties, okay, that has resulted in all this violence in Manipur. So whether that has to be dropped and all. So these are main issues we are discussing. And these are facts for prelims. FSDC means Financial Stability Development Council. So we look into the functions, who will head and all. Then Cabinet Committee on Security. So why this is there, I'll explain again. So we have some context of this. IBSC Fund, UNSK, you have. Munich Security Conference, you have. And Rani Chennamma, she is also in news because of some reason. I'll explain. Then anti-satellite weapon was also tested by one country and we have the same technology. In that context, you need to know. Then another country joined this ISA. What is this ISA? International Solar Alliance. So we'll look into that also, right? So first thing is financial devolution. So normally, financial devolution means that is a job of whom? Who has to devolute the finances between two organs of the government? Normally in India, who does the job? No. Finance Commission, right? So if whatever the money that center is earning and whatever the money that states are earning, so that will be shared among these two by the Finance Commission. That is the primary job of the Finance Commission, right? So Finance Commission, it has to decide how much should be divided between center and states. So this issue is causing so much of trouble between center and state in fiscal domain. So what is the reason is, if you have seen in the recent past only, Karnataka Chief Minister and Kerala Chief Minister, they have protested in Delhi, okay, saying that how much we are paying, we are not getting in the same amount or more than that in return. Whatever we are paying is more and we are getting is very less in return. That is what they have said. So why these states are going there and demonstrating? What are the issues that we are going to discuss here? So first thing is, you need to know there are different taxation powers, no? Again, in the center-state relations, like we have administrative relations and also we have legislative relations, okay? And before going into financial relations, there is no judicial relations divided, right? But in legislative relations, you know, parliament in their own domain, that is in union list it can legislate, states in their state list, and you have third list, that is residuary list, where who can parliament, right? In parliament only it can pass the laws for residuary matters, yes or no? Then we have in 5 abnormal situations, parliament can also enact laws on state list issues, yes or no? What are those state list issues? In what are 5 situations where the parliament can enact laws on the state list subjects? National emergency, president rule, very good, to enforce international treaties. How many? Means 2 or more states. If they request the center to legislate, then parliament, and do remember in this context, only to those states it will apply, not to all the states. Okay, those states which have requested, for them only the new parliament law will apply. Okay, and then 5th one. What is Article 249? Rajya Sabha in the national interest, if it thinks so, okay, then it can initiate the process under Article 249. Then also Parliament has a special power to legislate in the state aspect. Okay, so this is a 5 abnormal situations where Parliament can enact laws in the stateless subjects, right? These are the things you have to remember. Now coming to the financial domain, you know, same way we have powers of financial powers divided between Parliament and state in their respective domain. Means union list subjects can be taxed by the Parliament and state list subjects by the states. Like that previously we used to have union taxes and, or central taxes and state taxes. But you know, in the recent times we have this introduction of GST. Okay, with that many of the indirect taxes got subsumed under GST. So what happened in GST also, we have 3 types again: CGST, SGST and IGST. So CGST and IGST are brought under Parliament's domain, and SGST means whatever the state GST is imposed, all that money they can keep for themselves. Yes or no? So in all these indirect taxes and other taxes also, and you know, income tax and all these. So these are direct taxes. So in direct taxes like income tax and corporation tax, or in indirect taxes also, the main power, like you can say large volume or large proportion of taxes goes to the center, right? But states are taking more responsibility, yes or no? So for that, what they have to do? If center is earning 100 rupees and states are earning only 20 rupees under their domain, okay, then what should be done? Again, out of this money also they have to get some shares, no? Center is not taking the immediate responsibility. States are having immediate responsibility in different things. So this again 100 rupees also have to be divided among center and states. Yes or no? This is what devolution we call. In this devolution also we have 2 types of devolution basically. So here you should understand horizontal and vertical, 2 types we have. Horizontal devolution will come later, we'll discuss that later, but vertical devolution means when center and states, okay, how much of this 100 rupees, how much center should keep it with itself and how much states should get. Okay, this is what we determine through vertical devolution. How much this amount is determined by whom? Finance Commission. Okay, that means if you have remembered previously 14th Finance Commission under Y.V. Reddy, they have recommended 42%, ante 100 rupees to 42 rupees అనేవి states కి వెళ్ళాలి అని చెప్పి devolution చెప్పారు. అది vertical devolution, center నుంచి states కి వచ్చేది. Okay, clear? But 15th Finance Commission, what did they say? They said 41% should go with the states and 1% they said for newly formed Jammu and Kashmir Union Territory. So in this way, now 41 rupees is going to the states again from the 100 rupees which center is earning, right? Clear? This is what vertical devolution we call. Then among this 41 rupees also, 41 doesn't go to one state, no? It has to be divided among different states, right? But again, you know, in India, every state is not uniform in terms of area or population. So there are some big states in terms of area and some big states in population. Which is the largest in terms of area? Rajasthan. In terms of population? UP. So there are smaller states also and union territories also. There are different number of things, no? In this context, you need to know not every state will get equal share. Okay. So on what parameters again you are dividing this particular amount among the states? That we call as horizontal devolution. Okay, horizontal devolution means states మధ్యలో ఎట్లా పంచుతున్నారు అనేది horizontal devolution. So for that, every finance commission is following some set of parameters that I'll give you in the table, you'll understand. So basically, first thing you need to know is why we are discussing this amount of why we are discussing this aspect of financial devolution is southern states, okay, like I have given already example, Kerala and Karnataka, they demonstrated, protested. And some other states, even when Telangana is also, the previous government also, they have raised their objections. We are paying more and we are getting very less from the center. In this context, we are discussing. And I told you what is the role of finance commission. In vertical devolution, in horizontal also, it is the finance commission's job to determine how much should be paid to the states. So here it is having the powers under Article 280 of Indian Constitution, right? You know the basic facts about finance commission, I'm just explaining. So it is a constitutional body. And you know, it is the chairperson and members. How many? 4 members and 1 chairman. So they will be appointed by the President of India, even within 5 years of time or even earlier also. Before 5 years also, if he thinks that there is a need to appoint finance commission, even then also he can do so. So then, what are the qualifications of this chairman and members is not specified by the Indian Constitution. Do remember, it is not specified by Indian Constitution, but separately Parliament was given powers by the Constitution of India, where Parliament has enacted another act called Finance Act, in which it said these has to be the qualifications of chairman and members respectively, okay. So, and they enjoy a term of 5 years normally. Now, till now we have 15 finance commissions function already, and 16 finance commission was recently set up, you know, okay. Who is the chairman? Appointed Arvind Panagaria, former executive vice chairman of Niti Aayog, right? Okay. So this person, he will have, or this person's led the finance commission, 16 finance commission has to operate from 2026 to 2031. Until our 5-year period, they have to give recommendations, right? So this is a basic fact. And you know, this is only advisory in nature, although, okay. And I told you in the previous class also, if you do remember, that Finance Commission is a non-permanent constitutional body. It is non-permanent, okay. Every 5 years or earlier you're constituting. The same way I told you already, there is another body also. What is that body? In the very first class I told you. There is another constitutional body which is non-permanent in Indian Constitution. What is that body? Non-permanent constitutional body, same like Finance Commission. What is the type of another body? Most of you are there in the first class also. I do remember your faces. Yes? No? One, two, three. You are not there. 4. I can see your faces, I can remember. You are there right from the first class. Huh? 4 weeks లోనే గుర్తులేకపోతే ఇంత చదివి ఎగ్జామ్ లో how you can options okay, I'll give you some options. I have to frame options now, let me think to trap you. Okay, one is delimitation commission, second one ISC, I'm not going to interstate council, okay. It is very difficult to frame constitutional bodies which are non-permanent, right? So interstate council under Article 263 of Indian Constitution, it is also non-permanent in nature but constitutional, okay. Whenever it is necessary, then only President will constitute this interstate council. It is non-permanent in nature. Do remember this, right? Then you need to know there is an Article 270, okay, which is saying that there should be division of taxes. Finance Commission is 280, where it is dealing with devolution aspects. But Article 270 of Indian Constitution is saying that whatever the money that center is earning, that should be devoluted among the states. That power is there from the Article 270 of Indian Constitution. It is not typing mistake, it is 270 itself. Distribution of taxes between center and states is provided under Article 270 of Indian Constitution. Do remember this. Then you know what are the taxes or what amount is getting devoluted, okay. Which amount means you can see corporation taxes is direct tax where the companies will pay, right, among the profits then, and you have personal income tax. These two are direct taxes. So direct taxes are regressive or progressive? Progressive, because they depend on the paying ability, right? Then you have GST, central GST and also you have IGST. In IGST, some part will go to the states, center's share of IGST. So these two are again indirect taxes. So out of these 4 taxes money, all the money that is going to the center, that will be devoluted back to the states through vertical devolution. Among the states, it will be devoluted by horizontal devolution. Clear so far? Right. So here, this doesn't include cess and charge. This is a main problem. Okay. So why? Because in the recent times, almost out of 100 rupees the center is earning, 23 rupees is coming through cess and surcharge. So what is the main issue with the cess and surcharge? Before that, just let me know what is the cess and surcharge. What is the basic difference between these two? Example? For farmers' welfare. And you have clean energy cess, education cess we have, Swachh Bharat cess also we have, okay. That is with respect to cleanliness promotion. Means cess means for specific purpose it will be levied. But these type of taxes, they will be levied on specific things, but whatever the money that is generated from the tax can be used for anything, okay. You cannot demarcate this money. But for the cess money, on education cess, how much you are getting or how much amount you are receiving, that should be used only for again benefiting the education only. That means specific purpose, and that money can be only used for that specific purpose. That is what the meaning of cess, okay. This money need not be shared with the states. That is why states are raising their concerns. ఇప్పటి వరకు taxes చూసాం. ఆ tax లో ఎంత వస్తే అంత states కి ఎంత percentage recommend చేస్తే అంత ఫినాన్స్ కమిషన్ ఇవ్వాలి. దాన్ని చెప్పిన దాన్ని బట్టి. బట్ సెస్ ఎక్కువ ఇంపోజ్ చేస్తే ఏమవుతుంది? ఎంత వచ్చిన సెస్ ద్వారా అదంతా సెంటర్ కి మాత్రమే ఉంటుంది. దట్ ఈస్ వాట్ స్టేట్స్ ఆర్ నాట్ హ్యాపీ విత్. ఓకే. సో దిస్ మనీ through cess and surcharge need not be shared with the states. Okay, that is one provision. What is surcharge? It's a tax on tax. Okay, so those people who are earning more, okay, so they need to pay some amount of extra tax. You can say tax on tax. That is surcharge we call. So these two things need not be shared with the states. Clear? This is one another apprehension raised by different states. Then you can see here challenges. There is more increase in the amount of cess and surcharges levied in the recent times. Almost this is indivisible pool. Divisible pool gaadu. Indivisible ante it doesn't get any share in the from the states. You can say amount of each state gets back every rupee is varying steeply. Means northern states, what is the allegation the southern states made is, northern states like Bihar, if they're paying only 30 rupees to the tax in the form of tax, they're getting 40 or 50 rupees in return. But the Chief Minister of Kerala, when he protested in Delhi, he said almost we are paying 79 rupees, but we are getting only 39 rupees. Example I'm saying, okay. That means we are paying more and we are getting very less. So here how much they're getting is also differing very differently from different states. Again you can see percentage share in the divisible pool is also reducing for the southern states. This is what they have raised their objections. Means northern states are paying less but they're getting more, and southern states are getting less although they're paying more, okay. Then grant in aids. You know two types of things are there. Grant in aids means just a type of assistance which center provides to the states. Okay, some support assistance you can say. Two types of grants we have. One is statutory grant, another is discretionary grant. Statutory grant is under Article 275. So here statutory means it is it is mandatory normally. Okay, so whenever this has to be given, normally it will be given to all the states under 275. But discretionary grants are those only for some situations. For example, if there is any cyclone or something, we'll say cyclone or tsunami, if that is hit in any state, then for disaster relief or something will provide some assistance. So you will see in the news how 100 crores is given by the center or 500 crores is given. So that will be discretionary grant. That means states will be discriminated here. That means if center feels that the state has to get some more money, it can give. But statutory grant, there won't be such deviations, right? So, but what happens is in grants in aid, those are becoming more discretionary. That means center is going according to their discretion. They're not allocating all the grant in aids equally to all the states. That is also one another concern raised by the southern states in that particular protest, right? This is very important in terms of mains. Clear? 275 is statutory grants, okay? Two types of grants we have. Discretionary grants or like for special status states we have, okay, 90:10 like that. Those are discretionary grants we call, right? So then what is the basis for allocation? I told you already. 15 Finance Commission has recommended 41%, previous it is 42%. Clear? So this distribution is horizontal devolution based on the various criteria. What are those criteria? You can see it is blurred here. Income distance, population. So previously till 15 Finance Commission, we used to rely on 1971 census, but now 2011 census. That is why the southern states are raising, no, because 2011 census means southern states have adopted this family planning and population control measures. They have controlled the population. If more population is there and more taxes you will pay means southern states are a disadvantage, no? That is why they are not happy with these recommendations. So these are all the criteria which are adopted to divide among the states. ఇప్పటివరకు 41% సెంటర్ నుంచి స్టేట్స్కి చూసాం. స్టేట్స్ మధ్యలో ఎలా పంచాలి అనే దానికి ఇవి క్రైటీరియా అనమాట. ఓకే, సో వన్ ఈస్ ఇన్కమ్ డిస్టెన్స్, అంటే హైయెస్ట్ పర్ క్యాపిటల్ ఇన్కమ్ హౌ మచ్ ఇస్ దర్ ఇస్ హైయెస్ట్ ఇన్ హౌ మచ్ ఎంత అని, లేకపోతే సదర్న్ స్టేట్ ఆర్ ఎనీ స్టేట్లో లోయెస్ట్ పర్ క్యాపిటల్ ఇన్కమ్ ఎంత, అంటే ఎక్కువ వేరియేషన్ ఉంటే మంచిదా, వేరియేషన్ లేకపోతే మంచిదా, పర్ క్యాపిటాస్లో లేకపోతే మంచిది కదా, అంటే అందరికి కొంచెం ఈక్వల్ డిస్ట్రిబ్యూషన్ ఆఫ్ ఇన్కమ్ ఉంది అన్నట్టు. సో ఇది చూస్తారు ఫస్ట్. పాపులేషన్ అనేది ఇంతకుముందు 1971, ఇప్పుడు 2011 సెన్సస్ చూస్తున్నారు. తర్వాత ఏరియా, స్టేట్ ఏరియా చూస్తారు, స్టేట్ ఫారెస్ట్ కవర్ చూస్తున్నారు ఈ రీసెంట్ టైమ్స్లో. దెన్ వీ హ్యావ్ ఎకాలజీ ఆల్సో, ఇన్ఫ్రాస్ట్రక్చర్ డెవలప్మెంట్, ఫిజికల్ డిసిప్లిన్, అంటే వాళ్ళు ట్యాక్సెస్ని ఎంత బెస్ట్గా వాడుతున్నారు, వేస్ట్ అవుతున్నాయా మనీ అట్లా చూస్తారు. డెమోగ్రఫిక్ పర్ఫార్మెన్స్, ఆ స్టేట్లో డెమోగ్రఫిక్ పర్ఫార్మెన్స్ ఎలా ఉంది, ట్యాక్స్ ఎఫర్ట్స్ ఎలా ఉన్నాయి, మనీ ఇచ్చిన దాన్ని ఎలా యూటిలైజ్ చేస్తున్నారు. సో ఇవన్నీ డిఫరెంట్ పారామీటర్స్ని జడ్జ్ చేసి దెన్ బేస్డ్ ఆన్ ద బెస్ట్ పారామీటర్, బెస్ట్ స్కోర్స్ వచ్చిన వాళ్ళకి హైయెస్ట్ షేర్ అట్లా అన్నట్టు డివైడ్ చేస్తున్నారు స్టేట్స్ మధ్యలో. ఓకే, ఇన్ దిస్ వే ఇట్ ఈస్ వర్కింగ్ అవుట్. సో నెక్స్ట్, క్లియర్ విత్ దిస్? If you have any doubts, you can ask. Then second issue we have is money bill. Okay, so what is happening with money bill is, recently in electoral bond issue also we have seen Supreme Court said usage of finance bill method to pass this electoral bonds. Okay, so that is nothing but bypassing the Rajya Sabha or the legislative process. So in this context, Supreme Court is saying that confronted with what is a complex task of defining what constitutes a money bill. Actually, you know what is money bill means? Something which is related to taxation or whichever the money that is crediting into consolidated fund or withdrawal of consolidated fund or contingency fund. Like this we have some criteria, but in the recent times if you see almost different types of bills, they are saying like as the expenditure is coming out of consolidated fund, Aadhaar card related kuda bill, Aadhaar bill kuda alane chesaru kada, endukante Aadhaar unte beneficiaries ki mem pay chese amount consolidated fund nunche bayitiki veltundi kada ani cheppi government justified its stand. So it cannot be a money bill. So as a criteria మీద మీరు డిఫైన్ చేస్తున్నారు అనే దాని మీద Supreme Court is going to look into this issue. In this context, we are going to discuss as per this bill. Okay, so if you can see, this issue was also raised in the electoral bond scheme in the recent times, and 7-judge bench headed by the Chief Justice of India is going to look into this issue. So what is the criteria to designate a bill as money bill? So before that, you let me know what are the basic features of a money bill. I told you already on what grounds. Article is 110. Yes or no? 110 deals with money bill. So basic thing is there should be something related to taxation, means increase, decrease or change in proposal of taxation. That's the first basic thing. Then second thing is any money that is credited into consolidated fund, contingency fund or withdrawing the money, or any borrowings that government of India takes from the country, other countries or any other places, and also whatever the money that government of India receives in the name of interest payments or something. So all this money will be part of consolidated fund. So all that is concerned with money bill only. Okay, then who can initiate a bill, money bill? I'm not asking where you can initiate, but who can initiate a bill, money bill? I'm asking whether a minister can introduce or even a non-minister or like a normal MP also can introduce. Money bill means it is dealing with expenditures of the government, no? That means only government minister, that means only minister can introduce a bill. There is no chance of non-minister or MP introducing a bill. Okay, that means it is public bill, it is not a private bill. Yes or no? You know the basic difference between public and private, right? So in that context, that is the first thing you need to know. Then in which house it can be initiated? Only in Lok Sabha, and that too also on the prior recommendation of the President of India. Okay, so it cannot be initiated in Rajya Sabha. After initiating in Lok Sabha, then Lok Sabha can discuss, it can make amendments, it can vote, everything will happen in Lok Sabha. Then after transferring from Lok Sabha to Rajya Sabha, what Rajya Sabha can do with respect to money bill? It can recommend some, it can discuss, but it cannot alter. Okay, it can just recommend that you can adopt these changes to the Lok Sabha, but it cannot vote also. It can just discuss. Sometimes it can trap you. Can discuss is a possibility. That is correct. Okay, so in case if Rajya Sabha couldn't send back the money bill to Lok Sabha within 14 days, again what happens? It will be deemed to be passed by Lok Sabha. Okay, that means whatever the Rajya Sabha suggested amendments or that, those can be accepted or cannot be accepted by Lok Sabha. It is completely the choice of Lok Sabha with respect to money bill, right? Then who certifies the bill as money bill? Speaker only itself, right? Because it is getting initiation in the Lok Sabha. So along with the money bill, the speaker should send a certified copy that I am certifying this bill as money bill. Okay, that certification of the speaker has to be sent to Rajya Sabha when he is forwarding that bill to Rajya Sabha. Okay, then there is no provision of joint sitting. Then what are the options before the President of India? He has to give assent, not has to, he can give assent, and he can return for reconsideration, but he cannot reject the bill because it is already introduced with his prior consent. Okay, two options are available, but in case of constitutional amendment bill, there is no option, but he has to give assent. That was given again by 24th amendment in 1971, right? So these are the basic things you need to know about money bill. Here you can see what are all the things. So Rajya Sabha can only suggest amendments, as I told you already. So 110 exclusively deals with this taxation, government finances and consolidated fund of India related aspects. So three things untene, then we can call it as money bill. Okay, in the previous class I told you, all money bills are finance bills, but all finance bills are not money bills. Do remember that. Okay. Then who certifies? It is the final decision of the speaker. Okay, and do remember his decision cannot be challenged in the courts. In this context, it is out of judicial review. But in other things like defection, the decision of deciding on defection grounds can be challenged. That means it is open to judicial review. But here in case of money bill, speaker's decision cannot be challenged. That is why most of the governments are resorting to this way. Okay. Then consolidated fund means, you know, basically we have three types of funds, right? Consolidated fund, contingency fund and public accounts. This is under Article 266 of Indian Constitution. So whatever, just simply remember, consolidated fund means every rupee government earns or every rupee that government spend, okay, in whatever the way it can be, all that will credit into and debit from this consolidated fund only. Okay. Contingency fund means, you know, for meeting unforeseen expenditure suddenly, if you want, because every time parliament will not be there, right? So consolidated fund nunchi roopayi bayatiki ravalana parliament has to give approval, then only government can use. But you know, every time parliament will not be there in session. So in those situations, if we need any extra money for emergency situations, that can be used from this contingency fund. This will be placed at the discretion of the President of India. Generally, Finance Secretary will maintain this fund on behalf of President of India. Then what are the challenges means? In case of Aadhaar case in 2018, you know, just now I told you, as the beneficiaries are getting paid those welfare schemes, for those welfare schemes from consolidated fund, government justified that it is a money bill. But this was challenged by opposition from then onwards. So Supreme Court said in this case also, it is whether it is constitutional or not. At that time they declared it constitutional only, but now again they are going to look into this. So Justice Chandrachud, you know, Chief Justice of India, he said passing the Aadhaar Act as money bill was abuse of the constitutional process. That is what he made a remark, okay, in this context. Then you can see in another case, it was also whenever this appellate tribunal rules were there, at that time also they tried to introduce it as a money bill, but it was struck down by the Supreme Court, okay, in different instances. Then in a larger bench, you know, in the recent times, whether this Finance Act of 2017 means, which has introduced electoral bonds. So this was also before the 7-bench judge bench. So they are going to look into this, whether this type of bills can be introduced in the form of money bills or not. Okay, in this context, you need to know about money bill. Clear with this? So next we are going to discuss about some famous cases of Supreme Court judgments, I mean. So why? Because, you know, in the recent times, an eminent jurist, Nariman, yes, so he passed away. So he was instrumental in some Supreme Court judgments. So in the context of Indian polity and constitution, which are useful for your examination, I have included here, right? So first thing is, you know, he's a jurist. So this is a criteria for becoming a Supreme Court judge. So if the President of India feels that he's an eminent jurist, then he can be appointed as Supreme Court judge. That is one of the criteria apart from 2. What are the other 2? 5 years as a High Court judge or 10 years of advocate practice. Third one is eminent jurist. This jurist provision is not there for the High Court judges, do remember, okay? Then emergency period, during this period he served as additional Solicitor General. So what is this position? Solicitor General, whether this is mentioned in the constitution? This is not mentioned in the constitution. What are mentioned? Only Attorney General at the center, Advocate General at the states. Do remember. There is no provision of Solicitor Generals. This we have placed for our convenience. Okay. These will assist the Attorney General because so many cases the government will be litigant. No. So in case if central government has to represent itself, Attorney General will appear in the courts. But on the same day, in 3 different or 4 different places they have to appear. Then it cannot be possible by one person. No. That is why to assist this person we have Solicitor General, under which again we have some additional Solicitor Generals, means on behalf of the government they represent in the different courts in India, okay. So he was the person at that time, but immediately after imposing the emergency he resigned, okay. Then, so he have been awarded with Padma Bhushan and Vibhushan. This is a state, in case if they ask for state exams, I will just give you. Here also these are important for state exams only, some books, okay. So as his prominence and significance is very much in the Indian judiciary, they can ask, state PCS I'm asking, okay, I'm dealing with. So UPSC doesn't go into these things, but in case if any state PCS asks these type of questions, you need to know the works, okay. They can just simply ask this book or this is a work of whom, okay. So just note down if you want. You want it note down. Then some famous cases. First one is IC Golaknath versus State of Punjab. So what is this case about? Have you read about this case any time? Then in which chapter, in which subject? Polity. What is it about? Fundamental rights. Then you should know the brief facts of the case, right? Or just you will simply remember the case name. For God's sake. Generally, when you're coming across different cases, okay, so don't just mug up the case name, just understand what is the case about, the brief facts, okay. So very brief facts if you understand, then you can easily remember the case and its judgment easily, right. So here, Golaknath, Henry Golaknath and some brothers are there, they own some almost 500 acres of land in Punjab, okay, in 1965 around. At that point of time, in again Punjab state government, they passed a law. After independence we tried to limit the land by passing land ceiling acts. No, so states individually they have passed. At that time, Punjab government also have passed a land ceiling act placing maximum limit. So 500 acres is far above the maximum limit. No, so this person's land has to be given under this land ceiling act. So then what happened? Again, the state of Punjab has placed this law because at that time in 1965, I am saying at that time right to property is a fundamental right under 19. Yes or no? We have fundamental right. So they can easily challenge. That is why what did they do? The state of Punjab have placed the law which is imposing some lands maximum ceiling under 9th schedule of Indian Constitution, where if the law is placed under 9th schedule, it is out of judicial review. Yes or no? At that time. So intelligently they placed under 9th schedule. So then this person approached Supreme Court of India. He asked that as I'm having right to property as my fundamental right and also right to equality is there. So how land can be taken from my side, okay? So how the state government or Punjab can take my land and how this law will be valid. Okay, at that time 17th constitutional amendment was passed to include this state of Punjab law in 9th schedule. So he challenged the constitutional validity of this 17th constitutional amendment. So then what Supreme Court have observed? It is constitutional amendment which have placed this law under 9th schedule. So whether this constitutional amendment will fall under the definition of law under Article 13 or not is what first thing they have examined. They said, Supreme Court said, yes, at that time under Article 13, it is definition of law. Means what is under Article 13 normally, what is the definition or provision of Article 13? Any law which is against the provisions of constitution, okay, so that can be declared null and void by the judiciary. Yes or no? That means here the law means different types of things are there. Legislative things can be there, or executive orders can be there, decrees can be there, bylaws can be there, different types of things are there. But whether constitutional amendment can be included under law or not is the question. So Supreme Court at that time said even a constitutional amendment also can be considered as a law. Okay, that is why, so if the constitutional amendment can be considered as a law, then under 13 judicial review, this can be made a void or not, as it is violating your fundamental rights or as it is violating some provisions of the constitution, whether the state of Punjab law, which was placed under 9th schedule through constitutional amendment, can that be declared null and void by Supreme Court or not? I told you law means constitutional amendment. That is what Supreme Court said in this case. If it is under our ambit of Article 13, then it can be declared null and void, no? Through that, it said the law is constitutional amendment also. Then second thing they said is Parliament, whether it can amend or not with respect to fundamental rights. At that time means Golaknath judgment they gave clearly that Parliament cannot amend fundamental rights. That means in case if Parliament is given power to amend fundamental rights, then they can remove the right to property, right? Yes or no? Okay. After this Golaknath case only, again it was challenged, in Keshava and the Bharti case in 1973, 4 years after. So in that case only for the first time they said Parliament can alter, but with some restrictions that it cannot amend basic structure of the constitution. That means that was first time outlined by the Supreme Court in Keshwan and the Bharti case. Okay, that means till then, according to Supreme Court, Parliament cannot amend fundamental rights. Right to property cannot be taken. That is why by 44th Amendment 1978, after Keshwan and the Bharti case only, we could remove this right to property, which is a fundamental right, from the list of Article 19. Clear? Okay. In this way, in this particular judgment, he was also the main person who advocated on behalf. Okay. So in this case also he played an important role. Then Bhopal gas tragedy case we have. Okay. This is related to environment, where you have absolute liability and nuclear and principal liability. We have two things. So in this case, for the first time, Supreme Court has said there will be absolute liability on the persons. Absolute liability means, so even if there is an element of mistake and element of ignorance also, you have to compensate. And for example, in that industry, by human negligence, or even if by not knowingly also, if they have leaked some gas and it caused trouble or it caused loss of life to many people, at that time also, under this principle of absolute liability, they have to pay compensation, because this is the first major industrial accident that happened in India, right, in 1984-85 period, where almost more than 5,000 persons were killed in sleep itself. Okay, what is the gas that was released? Methyl isocyanate. Okay, that is a harmful gas that was released. So this is an American MNC. That is why we had this issue. In India only we can persecute Indians, right? So in Supreme Court and all. This is American MNC. So they said we cannot be under the Supreme Court jurisdiction and all. You cannot punish us, or you cannot ask us to pay compensation, and they have flown away. At that time, later on, again we went to American Supreme Court and they directed to pay compensation. In that way, this person, Nariman, he represented this Union Carbide Corporation in getting the compensation to the victims. Okay, this is one famous case. This case is also, in environment, who is considered as the most famous lawyer or advocate who will fight for all the environmental cases. You can write this in different number of pollution cases and deforestation related cases. MC Mehta, okay, a very good environmentalist. He fought many number of cases in terms of environment. Most of the cases you will see MC Mehta versus Union of India. All the time against Union of India, he fought so many cases in terms of environment. In deforestation, in pollution, you can write his cases. Okay, this is one example. Then in second judge's case, what is this second judge case about? What is this about? Supreme Court Advocates on Record versus Union of India case, also called second judge's case. This is related to collegium system, right? We have 4 judges cases, no? First one is SP Gupta versus Union of India. In that case, what happened? In terms of appointment of judges to Supreme Court and High Court or in transfers, okay? So President of India just has to consult. That is what they have said in the first judge's case. That means if President consults the Supreme Court judge, okay, in appointment and transfers, that is fine. But whatever he has suggested to the President, that is not binding on the President. That is what the reference from the first judge's case we have. But what happened in the second judge's case? They have completely shifted the stance. The judiciary said, no, consultation means concurrence. Means if you're consulting and he suggests something to you, that is the President of India, then they have to follow that same decision. Okay, you're not just in the namesake consulting, but you have to follow the advice given by the Supreme Court judges whom you consulted along with the Chief Justice of India. Here, in the second judge's case only, they said consultation means concurrence. Okay, what is suggested to you has to be followed. That is why, what did they say in this name of second judge's case is, they said judicial independence is there, no, that is one provision of basic structure. Basic structure itself is again purported by judiciary itself, no, it is not there in the constitution. In that they have included independence of judiciary, and they said to protect independence of judiciary, it is very much needed to ensure that these persons have to be consulted and whatever their concurrence is there, that has to be followed. In that way, the second judge's case have led to a new system of appointment called collegium system. Okay, Article 124 of Indian Constitution for Supreme Court judges and 217 for High Court judges. So these deal with appointment of judges. So in this way, we had this system of collegium that has taken birth from second judge's case. It is also called Supreme Court Advocates on Record versus Union of India case. In 1993, we have this system of collegium. Till then, we don't have collegium system. Okay. So here what happened is, in this collegium, they said President has to consult Chief Justice of India. Other than Chief Justice in any other appointment, he has to be consulted along with 2 senior most judges. Okay, that means here 1 plus 2, 3 judges of Supreme Court, senior most judges have to be consulted. That is what they said in second judge's case. In this case also, this Nariman is one of the party. Then you have third judge's case. In third judge's case, what happened? Already we have collegium set up in second judge's case only. But in this case, not 1 plus 2, they have expanded this to 1 plus 4 senior most judges. Okay, so that means the present collegium we have 1 plus 4 is the outcome of third judge's case. In this case also, Nariman, he has submission this with respect to court. Okay, in this case also he fought, and when President of India exercised Article 143 also, in the second judge's case also, he was there in that particular case. In 1998, we have this 1 plus 4, and you can see here it expanded the size of Supreme Court collegium, 1 plus 2 to 1 plus 4. In this way, he was also part of third judge's case. Then we have fourth judge's case. Okay, that means except first judge's case, in all 3 judges' case, he was one of the main you can say participant to the case. So NJAAC means National Judicial Appointments Commission. You know, this was introduced by the government in through 99 constitutional amendment in 2015. Okay, what is the main objective of this scheme or the particular constitutional amendment? They wanted to have collegium. We have seen, no, who are recommending now 1 plus 4 judges. They will prepare the names who have to become the Supreme Court judges or High Court judges. So the name will be sent from the judiciary to the Union Executive, okay, President or the Cabinet. So then what the government has to do, it can just refer the names, and if they have objection with any name, they can again send back to the collegium. Okay, but again, if collegium sends the same name, if they change, there won't be any problem. But if they send the same name, this time government cannot raise objection anymore. It has to again recommend to the President to issue appointment order. And apart from this, only IB checking, that means Intelligence Bureau will be there, no? They'll check about the particular record of the judge and all, that's it. That is the only job of the government. Means they don't have major say, no, in appointment of judges. So to cut down this, they have come with National Judicial Appointments Commission. Means they wanted to form a commission which will consist of 6 members. Okay, so who are the 6 members? 3 from judiciary, 3 from executive, they said. So CJ and 2 2 senior most judges will be there from the Supreme Court, 3 here, and you have Union Law Minister and also 2 persons will be there from civil society. Civil society means normal civilians will be there, but these civilians who will be recommending? Again, Prime Minister, Chief Justice of India and Leader of Opposition. This is what they proposed. Here 3 persons from the outside judiciary and 3 persons from within the judiciary. In this way, 6-member commission is going to get formed under this NJAAC. Then what is the contention here? In case if any 2 members object, then that cannot be passed. That is what the main hurdle they placed. That means government said how many are there? 3 are there. If any 2 members object also, that same decision cannot be passed. So that is one provision they said. So will this Supreme Court agree to this? Till then they have complete independence in appointing, no? Government has no major role. But now government is coming and intervening in the appointment process. Those said, okay, no, this is violating the independence of judiciary, which is guaranteed under basic structure. So they have totally made this null and void. That means NJAAC is no more. It was totally quashed by Supreme Court. So how many means? At that time also 5 judgments, because this is a constitutional amendment, no? Minimum 5 judges should be there in interpreting any provisions of constitution. Larger than that also you can have, but minimum 5 judges should be there. So out of 5, 1:4. You can say 4:1. 4 have given in favor of cancelling this NJAAC. Only 1 judge has given in favor of NJAAC. And he's the one person is from Telugu, that is Jasti Chalameshwar. Okay. Why did he support this NJAAC? Because he had some apprehensions that because of this collegium system only, he could not become CJ. That is what his apprehensions are. So he voted against collegium system in favor of NJAAC, but all other 4 have made this null and void. In this way, this was also cancelled off. That means 4 judges case is related to NJAAC, but it was subsequently struck off. Clear? Then another case you have is TMA Pai Foundation versus State of Karnataka case. This is very famous case with respect to minority rights. You know, under Article 29 and 30, we have some set of rights given to minorities, right? 29 and 30, which are fundamental rights, and those are only available to citizens of India, if you do remember. Okay. So in this context, if you remember the provisions of Constitution, Article 29 is applicable not only for minority but also for majority. That is what the statement made by Supreme Court in the previous case. Okay. In this case, what did they suggest is, even Nariman also argued that minorities should have, under Article 30 clause 1, minorities should have, here minorities means religious minorities and linguistic minorities, they can have the right to establish educational institutions of their choice. Okay. And here another important judgment passed as part of this case is, here states are having their freedom to decide who is religious minority and linguistic minority. Okay. States are given choice under this case. Till then, now that is why even if you see in the recent past also, center versus state, this is what the issue is. So center is saying, well, center is not happy that states can determine the minority status. But when it reached the Supreme Court again reaffirmed that same judgment, said states can have, because you can see religious minorities entamand unnaru India lo? 6 religious minorities unnaya. What are those? Simple kada, Muslims, Christians, Sikhs, Jains, Buddhists and Parsis. Yes or no? In 2014 we added last one is Jain. Okay, 6 religious minorities. These are notified by central government. But in terms of linguistic minority means what? Whatever the state official language is there, other than that, if you speak any other language, for example in Telangana it is Telugu and Urdu. If you speak any other language other than Telugu and Urdu, you will be considered as linguistic minority in Telangana. That means linguistic minorities cannot be uniform. No? In every state they will vary, right? Yes or no? So that is why Supreme Court said, in terms of identifying minority status, states should be given a prerogative. Okay. That means center cannot determine, because minority status is not uniform across the country. That is what, in this case, they said that people will have their right to establish cultural and educational institutions of their choice. At the same time, states can determine who can be religious minority and linguistic minority. That is a famous case. When you come across any question on minority, you have to quote this case. Very landmark case in terms of minority status. Then you have this Nabam Rabia case, recent case if you have remembered, where this I told you number of times. Arunachal Pradesh speaker, okay, or governor, when you know the government is there and there are some speculations that government lost majority. So then what is the role of the governor in that situation? Governor has to call the chief minister and he has to conduct a floor test. Yes or no? He should initially ask the chief minister. If there is some allegation, he cannot blindly say something. So he should call for a floor test. If it is proven that he has lost majority, then he can dissolve the assembly. Or he can ask any other party who is willing to form the government. Yes or no? But what happened in this case is the chief minister of Arunachal Pradesh, he decided one particular date for floor test, because calling for a floor test is also not discretion of the governor. They should ask the chief minister and the council of ministers only. Then what happened? The council have advised one particular date, but before that date only governor has conducted a floor test, because of which the chief minister has lost majority in the house. Then he approached Supreme Court. He said, whatever the date I suggested, on that day he did not conduct floor test. He conducted it before only. So because of which I lost majority. So please reinstate my government. Okay. Then this is the case. So in this case, Supreme Court has reinstated the same government, because he cannot prepone the floor test. He doesn't have any discretion. The date, everything has to be suggested. That means governor should only act on the aid and advice of the council of ministers. Even with respect to date of the floor test also, he should abide by the advice of the council of ministers. That is what the famous case of Nabam Rabia case. Okay, clear with this? Understood all the judgments? Any doubt? Judicial activism means, they say, when there is space and when the individual organs are not functioning, then we are acting. That is what the stand of the judiciary. But government is saying you are actively involving, and this is judicial overreach or judicial activism. So they'll say, like in terms of Article 142, whenever there is some void, so in the procedural delays if they happen, so we have some powers under 142, so we are doing justice only. They'll justify their own stand. But government, they should not allow, no. So what is their role? They have to do that. In case if they're not doing, then only the judiciary can intervene. But again, sometimes without asking the executive to perform also, judiciary will intervene. Like banning the firecrackers. It should initially ask the executive, no, to pass some order or to pass a law banning all the firecrackers. But in that situation, judiciary is showing extra judicial overreach and it is banning all the firecrackers before ordering the executive or legislature. Yes or no? They're not giving even time for them. So in some situations it is going beyond, and some situations it is within, and within the need, you can see. Clear with this? Now we are going to discuss about another important act, that is Wildlife Protection Amendment Act of 1972. So why we are going to discuss about this means, in the recent times, Kerala is requesting the union government, that is Ministry of Environment, especially to amend this provision of 1972 Act. Okay. So what is the reason is, you know, under this Wildlife Protection Act 1972, we have 6 schedules. Okay. So those are dealing with different provisions. For example, 1, 2, 3, all these are with respect to protection only, but varying levels of protection. Means Schedule 1 species will have high protection, Schedule 2 and 3 comparatively lesser protections. Okay. So means in Schedule 1, whatever the animals are placed or plants are placed, those things cannot be even hunted. Okay. In exceptional situations only. Like for example, you have remembered Tigress Avani. In Maharashtra, it has killed so many persons, at that time, 2 years back or 3 years back. At that time, that in Maharashtra, one tiger has killed so many humans. So tiger is under Schedule 1. Means when it is causing lot of trouble only, you can, with the authority of the central government, with the permission of the central government, then only you can kill the tiger or whichever the animal that is placed under first schedule. But in second and third, sometimes easily you can get the permissions for killing that animal in case if it is posing some danger to our life. Okay, that has to be proven first. In Schedule 4, what we have? Schedule 4 deals with what? Of Wildlife Protection Act. What do Schedule 4 deal with? Yes? No? What do Schedule 4 deal with? Schedule 5? Schedule 6? No? No idea at all? You don't know about this act entirely? No? At least nod your heads, right? I'm not going to punish you. Just simply sitting as Buddhas in the class. Huh? Not even, you're just meditating, open your eyes. Just not even answering, not even nodding, yes or no also. You're both always laughing. Huh? Okay. Anyway, I'll explain all the schedules, but just understand what is the main issue here. This Kerala government wants to amend this act. Why? Because some animals like wild boars, wild pigs, they will be attacking humans and they'll be attacking the crops also. Sometimes damage also will be done to crops. So in the situation under Schedule 5 of this act, there is a provision that vermin animals can be hunted. As I told you, Schedule 1 to 3, they have highest protection. Okay, that means under exceptional situations only, with permissions you can hunt. Okay, but if any animal is causing danger to human life, or if it is causing damage to any particular crop or agriculture or food things, then if that animal is declared as vermin by central government, then without permission also you can hunt and you can kill these particular animals. That is what the provision of Schedule 5 of Wildlife Protection Act. So now, but who can declare this animal as vermin? That means central government. Central government, under which you have Chief Wildlife Warden. Okay, it is one of the statutory posts. Chief Wildlife Warden means generally IFOS officers will be there. So they will be Chief Wildlife Warden means entirely for country, one Chief Wildlife Warden will be there. So he will take the decision deciding which animal should be placed under vermin. So if it is placed under vermin list on the Schedule 5, then only you can hunt and you can kill if it is causing danger to you or your crops. Okay, but this power is with whom? Central government authority. It is not with the state government authority. So now Kerala is asking this declaring of vermin status, this instead of giving to Chief Wildlife Warden, give it to Chief Conservator of Forest, that is state highest IFS post. That means state level post. And ప్రతిసారి సెంట్రల్ కి అపీల్ చేసి సెంటర్ డిక్లేర్ చేసేంత వరకు డేంజర్ ఆపలేం కదా, మనం చంపేస్తుంటారు లేకపోతే క్రాప్స్ కి డ్యామేజ్ జరుగుతుంది. సో ప్లీజ్ ఇష్యూ దిస్ టు ద లోవర్ అథారిటీస్, దట్ ఈస్ చీఫ్ వైల్డ్ లైఫ్ వార్డెన్ నుంచి చీఫ్ కన్జర్వేటర్ ఆఫ్ ఫారెస్ట్. అది స్టేట్ లో హైయెస్ట్ పోస్ట్. చీఫ్ సెక్రటరీ మనకి ఐఏఎస్ లో ఎలాగో ఐఎఫ్ఓఎస్ లో చీఫ్ కన్జర్వేటర్ హైయెస్ట్ పోస్ట్, వాళ్ళకి ఇవ్వండి. అంటే స్టేట్ గవర్నమెంట్ జ్యూరిస్డిక్షన్ లో ఉంటుంది అప్పుడు. సో ఆ పవర్ ఇస్తే మీరు మాకు ఈజీగా ఉంటుందని చెప్పి కేరళ అడుగుతుంది రీసెంట్ గా. దట్ ఈస్ వాట్ ద ఇష్యూ ఇస్. Okay, here what type of question can be asked is who have the authority to declare that animal as vermin, and they can even ask about Wildlife Protection Act, all the schedules. Okay, so here that is why you have to discuss this. So now what is the issue? Kerala wants the center to amend this because there is increasing human animal conflict. Human animal conflict means these wild boars or elephants, they're having conflicts with humans. They will be interacting, they'll be coming into human life, and not they are coming, we are encroaching into their parts and we are facing the issues with animals, right? Wildlife conflicts. So here the primarily they are focusing on two aspects. One is section 11 of this act regarding hunting permissions. For them to hunt, what should the basic criteria? It should be placed as vermin. So hunting power will be there with the state government officials only, but for that to happen, first it should be declared as vermin, but this power is with the central government, Chief Wildlife Warden. That is what they're asking. If you delegate this power to the Chief Conservator of Forest, then it will be easy for us to operate this process. Okay, in this context this issue is there. So here I told you, it grants section 11 of Wildlife Protection Act, it grants the power to Chief Wildlife Warden, which is a central authority post, in declaring any animal. In case if it is dangerous to human life, this can be declared as vermin. Okay, the granting status of vermin will be done by this person. Then you can see Kerala is demanding transfer these powers from Chief Wildlife Warden to Chief Conservator of Forest. So this change will easily streamline the decision making process and allow more localized decisions, because in Kerala we have more elephants, Karnataka, Kerala, But in some other states, some other animals can be there. But every time approaching center for granting vermin status can be a time-taking process. No? That is why Kerala is asking these amendments. So declaration of wild boar as vermin. If wild boar is nothing but an animal, wild animal. So for section 62 of Wildlife Protection Act, Union government, that is Chief Wildlife Warden, can categorize any animal which is placed under Schedule 2. Do remember, it is not Schedule 1. Whichever the animals that are placed under Schedule 2, those can be declared as vermin for specific reasons and specific period and specific area only. For example, if they declared this animal in vermin in Kerala, that does not apply to Telangana or Karnataka. In that area only, for specific time only, they will be in time operation. Okay, do remember this very important provision. And this does not apply to Schedule 1 animals. In any case, you cannot hunt Schedule 1 animals. Under very exceptional situations only, you are allowed to hunt or kill Schedule 1 animals. It is not that easy. So Kerala is urging the center to declare these wild boars as vermin. That is why. Okay. Now, what is the issue is to classify this as vermin, you have to lose. At the time, what happens is, if it is declared as vermin, wild boars can be hunted and killed without any issues. Okay. That is what the state of Kerala is asking. Here you can see these are the reasons why they are asking for these amendments is increasing human-animal conflict, means wild boars are attacking or elephants are attacking and killing humans, increasing this, and agriculture impact is also there. That means crop loss is there. Then you can see here efficiency of previous, inefficiency means previously also shooters were employed, licensed shooters to kill the wild boars and all, but still those are not effective. That is why they are asking to declare them as vermin. So now you need to know what are the features of this act, Wildlife Protection Act schedules. So do remember in 1972 Act we have 6 schedules, okay, but in 2022 we have this amendment passed and we have only 4 schedules now, okay. This is most important thing, 4 schedules only we have. So 1 and 2 schedules you can see most endangered animals, most important animals which are have to be conserved, so they can be strictly prohibited. You know, black buck, Sultan, you know, Salman Khan has been prosecuted for the hunting of black buck. It is under Schedule 4. It is not under Schedule 1 or 2. If it is under Schedule 1 or 2, it will not be in films anymore. Okay. And I told you, I discussed or not, I don't know, but Bishnoi tribes. So if you have remembered, Bishnoi tribes, those people or those who have fought against Salman Khan, because these Bishnoi tribes in Rajasthan, they consider these black bucks as their childs. Even they breastfeed them also, the women, to the deers and all. That is what religiously they'll think, and they're more connected with environment. That is why they have fought for black buck against Salman Khan. You know how much famous he is, but tribes have fought against Salman Khan because of this issue. That is why it became sensational at that time. Okay, and Schedule 3 and 4, these are not necessarily endangered, but still hunting is allowed only with a license. Okay, that means first and second schedule has highest protection, third and fourth schedule have least protection. With some license from the Chief Wildlife Warden, you can also hunt. Okay, but without license, Salman Khan has meant for hunting. That is what the main reason for that issue. Then Schedule 5 I told you, vermin animals. Okay, Schedule 6 you have some plants cannot be cultivated. అంటే మనకి ఇల్లు ఉంది కదా, మట్టి ఉంది కదా, టెర్రస్ ఉంది కదా అని ఏ ప్లాంట్ బట్ ఆ ప్లాంట్ పెంచుకోకూడదు. ఓకే, కొన్ని ఉంటాయి కదా, మరిజోవా అని కానీ గంజా ఇలాంటివి ఉంటాయి కదా. ఓకే, సో ఇలాంటివి మనం ఇంట్లో పెంచుకోవడానికి ఉండదు. దట్ ఈస్ వాట్ ప్రొహిబిటెడ్ అండర్ Schedule 6 of Wildlife Protection Act. Okay, these are all part of 1972 Act, but now we have only 4 schedules as I told you. What are those? Schedule 1 and Schedule 2. These two again are protecting, they're giving protection only. You have Schedule 3. Here there is some plants. Ikkada Schedule 6 ela undo, ikkada kotta act lo Schedule 3 lo icharu protection of plants. Then you have Schedule 4 to comply with CITES provision. CITES, you know, Convention on International Trade in Endangered Species. So to comply with this, Schedule 4 is inserted. Okay, now we have only 4 schedules in 2022 Act. Clear with this? And when you're revising about Wildlife Protection Act, do remember which are all the bodies constituted under it. Okay, number of times I told you these type of questions can be asked in environment. Okay, what are the bodies that are constituted under Wildlife Protection Act? First one is National Tiger Conservation Authority. Okay, you know, this is the main body which is implementing Project Tiger. It was on the recommendations of Tiger Task Force. This is also a statutory body established under Wildlife Protection Act of 1972. Then you have National Board for Wildlife. Okay, what is the job of this? With respect to national parks and wildlife sanctuaries, if there has to be any change in boundary, okay, that means if there is some national park like this, but suddenly the government wants to decrease the size of national park. Why means, you know, developmental purpose. Okay, if they wanted to alter the boundaries, then it cannot do on its own, because I told you in the previous class, notifying a national park and wildlife sanctuaries with the state government only. But with that prerogative, they cannot decrease the size of national park or wildlife sanctuary. This cannot be done except with the approval of National Board for Wildlife. This is headed by the Prime Minister of India. They have to give permission in case if there is any change in the boundary or alter in any area. If you want to increase or decrease an area of national park or wildlife sanctuary, that has to be done with the permission of National Board for Wildlife. This is also a statutory body constituted under Wildlife Protection Act. Okay, this NTCA is not headed by like Prime Minister. Do remember, this is headed by the Prime Minister of India. Okay, and there is another body also you will come across, that is Animal Welfare Board of India. Okay, do remember, this is generally you will think that this is also under Wildlife Protection Act. Okay, seeing the name Animal Welfare, but this is not under Wildlife Protection Act. There is a separate act called Prevention of Cruelty to Animals Act 1960. Jallikattu, you know, during that time, this is a body, Animal Welfare Board of India. Okay, don't get into this trap. This is not under Wildlife Protection Act. Prevention of Cruelty to Animals Act. There is a separate act. Okay. Then the most important issue of the week, I can say, because Supreme Court has given a new definition of forest. Okay, so very important, and it is a highly probable topic for this prelims. What is the issue about? Okay, so first thing you need to know is we have Forest Conservation Act of 1980. Already we have 1980, that was subsequently amended, and we have another act in 2023. Okay, but before this you need to know there is another case called Godavarman case. Okay, in this case what happened is, again, Nilgiris, you know, in Tamil Nadu, where, okay, so when Nilgiris are getting cut down because of illegal timber plantations and all, so that person Godavarman approached Supreme Court to ask them to stop the cutting down of the Nilgiri forest. He wanted to protect them. Okay, in that case, what did the Supreme Court say? What is actual definition of forest? Okay, and that is what the question before the Supreme Court. And then what did the government say? Government said only the forest means which are those registered as forests on the government records, whether it is protected forest, reserved forest, a type of forest aina government records lo forest ga unnayi maatrame forest ani chepparu. Ante private, ఇప్పుడు కొంతమంది ప్రైవేట్స్ కమ్యూనిటీస్ ఫారెస్ట్ ఉంటున్నాయి కదా మనకి, రిజర్వ్ ఫారెస్ట్ కాకుండా కమ్యూనిటీ ఫారెస్ట్ ఉంటున్నాయి, ఇలాంటివన్నీ ఫారెస్ట్లే కాదు అన్నట్టు డెఫినేషన్లో గవర్నమెంట్ చెప్పింది సుప్రీం కోర్ట్ దగ్గర. సో దెన్ సుప్రీం కోర్ట్ సెడ్ నో, డిక్షనరీ నేమ్ ఆఫ్ ద ఫారెస్ట్ ఏముంటుంది, డిక్షనరీ మీనింగ్ ఏముంటుంది, డిక్షనరీ మీనింగ్ ఏంటి ఫారెస్ట్కి? డెన్స్లీ కవర్డ్ ఏరియా విత్ ట్రీస్ అండ్ కానోపీ, జనరల్ డెఫినేషన్ అదే కదా. సో అంటే గవర్నమెంట్ ఏం చెప్తుంది, గవర్నమెంట్ ఓన్డ్ థింగ్స్ మాత్రమే ఫారెస్ట్ అని చెప్పింది, దానికి మాత్రమే ఫారెస్ట్ కన్జర్వేషన్ యాక్ట్ అప్లికబుల్ అవుతుంది, మిగతా వాటికి అప్లికబుల్ అవ్వదు. అంటే ప్రైవేట్ పర్సన్స్ ఎవరైనా ఫారెస్ట్ని పెంచితే అలాంటివి ఈజీగా క్లియర్ చేయొచ్చు అన్నట్టు గవర్నమెంట్ చెప్పింది సుప్రీం కోర్ట్ దగ్గర. బట్ సుప్రీం కోర్ట్ సెడ్ నో, యూ హ్యావ్ టు యూస్ డిక్షనరీ మీనింగ్ ఆఫ్ ఫారెస్ట్. అంటే irrespective of ownership, irrespective of the size, irrespective of the record, anything which is having characteristic of a forest will be applicable under Forest Conservation Act. So the first thing you need to understand is this. Okay, then what are the issues? So recently also what happened is, again this judgment, okay, so what happened is in the recent times we have this 2023 amendment. What happened? 1980 Act, the name itself is suggesting forest conservation, no? Means you need to protect forests, but compared to 1980 Act, 2023 Act became so worst. you can say, in terms of environmental damage, because previously there are no much exemptions given under 1980 Act. For example, only exemption given is in case if a forest land is there and if you want to cultivate any commercial crops like tea, coffee or something, or horticultural crops, you know. Horticulture crops means onions, tomatoes, potatoes, these things, okay. So in case if you want to cultivate these type of things, then you can cut down forests and you can cultivate. That is the only exemption given in 1980 Forest Conservation Act. But in 2023 Act, what did the government introduce? Not only these, in case of any border areas, you know, international borders. So in case if you want to develop any infrastructure in the border areas, then you will be exempted under Forest Conservation Act. Means forest conservation అంటే ఏంటమ్మా, ఫారెస్ట్ని పెంచమని కదా అర్థం. ఫారెస్ట్ పెంచడానికి ఆ యాక్ట్, కానీ మీరు ఫారెస్ట్ని కట్ డౌన్ చేస్తున్నారంటే ఎలో చేయదు కదా. అలాంటి వాటికి ఎగ్జెంప్షన్స్ ఇవ్వడానికి కొన్ని 2023లో మోర్ ఎగ్జెంప్షన్స్ ఇచ్చారు. అంటే ఏంటి, ఎక్కువ ఫారెస్ట్ కట్ చేయడానికి ప్రొవిజన్స్ ఇచ్చినట్టే కదా మనం. దట్ ఈస్ వాట్ ద మెయిన్ కంటెన్షన్ ఇస్. ఓకే, 2023లో దే హ్యావ్ expanded the scope of exemptions compared to 1980 Act. 1980 only one provision is there, that is they can allow for commercial and horticultural crops, that's it. Okay, but in 2023 they said not only commercial and horticultural crops but also for infrastructure upgradation along the boundary areas, or even for example if there is a forest and if tribal people wanted to promote ecotourism, you know, ecotourism and all, so at that time also central government, to increase the livelihood opportunities of those tribal people also, they can divert forest land to these purposes. That means again another exemption was granted. In this way, if these many exemptions are granted, then what happens? Slowly forest area will get out, no? Yes or no? In the border areas you are saying, border areas, what is the stand of the government? They said, for example, you know, like along the China border you can say, Uttarakhand you have, so those states are having border, no? So in case if China is building its infrastructure along the border, and if you are not able to grow the, you can say, or if you're not able to increase the infrastructure facilities like roads and all, you know, thick forest will be there, no? If you're not able to increase, then it will be a problem for defense and security. That is what the stand of the government is. But at the same time, the Supreme Court did not agree to this. What did they say? The government records will not be there. You have to see the dictionary definition of forest. So you are saying whichever the forests are there only in the government records, those are considered as forests, but that is not the actual thing. You have to consider irrespective whether it is government land or private land, anything which is falling under the dictionary meaning has to be protected under this act. That is what first thing they said. Okay, second thing is, I told you in the recent times almost 1.97 lakh square kilometers of forest land got diverted. That is why some environmentalists, they have approached Supreme Court asking Supreme Court to intervene into this issue. Okay, in the name of Forest Conservation Act, the government is diluting the forest. That is what the main stand they have taken before the Supreme Court. Then you can see here, definition of forest. If you see, there is no clearly accepted definition. That is why all these issues are there. Okay, so what did this 2019 Forest Advisory Committee mean? They said there cannot be uniform criteria. Means you cannot apply same definition across the country, but states have the right to determine their own definition. That means in one state if private land is a forest, in another state it cannot be also. That is what the main thing that was said in this Forest Advisory Committee means. It will suggest whether forest can be used for non-forest purposes or not. That is the main job of this committee. So it said it cannot have a uniform definition. States can have their own choice in determining what can be a part of forest. So this is what they said. Then what happened? At this time, the state's prerogative to define the forest, okay, this mainly was called from this T.N. Godavarman case. Okay, so later on what happened, you can see in Godavarman case, to protect the Nilgiri forest against illegal timber operations, this case was filed. And you know, as I told you, the meaning of the word forest, that is what the Supreme Court has focused. Dictionary meaning ni chudali and forest vishamlo ani cheppindi case lo first time. So it includes all statutory recognized forests, whether reserved, protected or otherwise. That means any type of forest will be brought under this definition according to Godavarman case. So next you have to understand important issues. I told you 1980 Act. Main objective enti? To protect forest. Forest conservation, the name itself is suggesting protecting forest. Second is empowering central government to regulate this extraction of forest resources. At the same time, ఫారెస్ట్ నుంచి రీసోర్సెస్ కూడా కావాలి కాదు, దానికి ఎవరికి అథారిటీ ఇచ్చారు? సెంట్రల్ గవర్నమెంట్కి ఇచ్చారు. అంటే ఇఫ్ దే వాంటెడ్ టింబర్ అండ్ బ్యాంబూ అండ్ అదర్ థింగ్స్, దే కెన్ టేక్ ఫ్రమ్ ద ఫారెస్ట్. ద గవర్నమెంట్ ఈస్ హ్యావింగ్ పవర్. బట్ వాట్ హ్యాపెండ్ ఇన్ 2023? The same act is also saying we have to preserve forests and to protect the climate from climate change and all, we have to protect the forest. The objective is fine, okay, but land notified in any government can be recorded as forest. అంటే ఇక్కడ ఫారెస్ట్ కన్జర్వేషన్ యాక్ట్ లో కొత్త డెఫినేషన్ తీసుకొచ్చారు. గోదావరిమన్ కేసులో ఏం చెప్పింది సుప్రీంకోర్టు, ఎక్కడ ఉన్నా కూడా ఫారెస్ట్ ల్యాండ్ అని చెప్పింది. బట్ ఫారెస్ట్ కన్జర్వేషన్ యాక్ట్ లో ఏం చెప్తున్నారు కొత్తగా, మేము ఆబ్జెక్టివ్ ఆఫ్ ద యాక్ట్ ఏంటి, టు ప్రొటెక్ట్ ఫారెస్ట్ అని చెప్తున్నారు. బట్ ల్యాండ్ అంటే ఫారెస్ట్ అంటే ఏంటి, ఓన్లీ గవర్నమెంట్ రికార్డ్లో ఫారెస్ట్గా నమోదైంది మాత్రమే ఫారెస్ట్ అని చెప్తున్నారు. అర్థమవుతుందా, అంటే వాళ్ళు వీకెండ్ చేస్తున్నారు డెఫినేషన్ ఆఫ్ ఫారెస్ట్. సో దట్ ఈస్ వై నౌ సుప్రీం కోర్ట్ హ్యాస్ ఇంటర్వ్యూన్. సో దీంట్లో ఉన్న ఇష్యూస్ ఏంటి అంటే, ఐ టోల్డ్ యూ ఆల్రెడీ, దీస్ ఆర్ ద థింగ్స్ ఫర్ వేర్ దీస్ ప్రొవిజన్స్ విల్ నాట్ అప్లై. ఫర్ ఎగ్జాంపుల్, ల్యాండ్ లీగల్లీ డైవర్టెడ్ బిట్వీన్ 1980 to 1996 వీటి మధ్యలో నాన్ ఫారెస్ట్ యూస్కి ఓకే తీసుకొచ్చినప్పుడు ఆ డైవర్టెడ్ ల్యాండ్కి ఈ ప్రొవిజన్స్ అప్లికబుల్ అవ్వవు. అంటే యూ కెనాట్ ఆస్క్ ఇన్ కేస్ ఇఫ్ ఫారెస్ట్ ఈస్ డైవర్టెడ్ ఆల్సో. దెన్ సెకండ్ థింగ్ ఇస్, ఇఫ్ ద ఫారెస్ట్ ఈస్ సిచ్యువేటెడ్ 100 kilometers away from the international border, అంటే within 100 kilometers of the border you can cut down forests and no one can question this because it is having some exemption under Forest Conservation Act. Then land ranging from 5 to 10 hectares for security and defense purposes. Okay, below 5 hectares if you clear any land there won't be any objection, you should not raise any objection. అంటే above 5 hectares of land అయితే ఇలాంటి వాటికి exemptions వస్తాయి. Below 5 hectares you cannot question also in case if the land is diverted. Above 5 hectares only these provisions will apply. So main thing is the act is specifying some acts. I told you already, చెక్ పోస్ట్లు పెట్టుకోవడం కానీ, ఫెన్సింగ్, బ్రిడ్జెస్ ఇలాంటివన్నీ బార్డర్స్లో పెట్టుకోవడానికి ఫారెస్ట్ని క్లియర్ చేసిన యూ కెనాట్ క్వశ్చన్. దట్ ఈస్ ద మెయిన్ ప్రొవిజన్ ఆఫ్ దిస్ యాక్ట్ విచ్ ఈస్ కాంట్రవర్షియల్. అండ్ ఆల్సో ఇట్ ఈస్ అలోయింగ్ టు రన్ జూస్, సఫారీస్ అండ్ ఎకో టూరిజం ఫెసిలిటీస్. ఇలాంటివి పెట్టడానికి కూడా ఫారెస్ట్ క్లియర్ చేయొచ్చు అని 2023 యాక్ట్ చెప్తుంది. అంటే వీటన్నిటిలో కూడా ఏం చెప్తున్నారు, ఫారెస్ట్ని కట్ చేసుకోవడానికి వాళ్ళకి ఎక్కడ కుదురుతుందో అవి ప్రొవిజన్స్ ప్రొవైడ్ చేశారు. ఓకే, దీనివల్ల చాలామంది ఎన్వైరన్మెంటలిస్ట్ దే అప్రోచ్ ద సుప్రీం కోర్ట్ నౌ. They said inni provisions iste that will easily get diverted, and they said data almost, I told you 1.96 lakh square kilometers of forest divert ayindi 2023 lo idi teeskochinappadi nunchi. So issue entante, first thing ikkada oka regional empowered committee ane center form chestindi ee forest amendment act kinda, forest conservation act kinda. Deentlo entante veellu decide chestaru land divert cheyocha cheyodda ani. Okay, ee power evarki icharu, center ki icharu. Okay, ఈ కమిటీ ఏం చేస్తుంది, గ్రేటర్ దాన్ 5 hectares ఆఫ్ ల్యాండ్. 5 hectares అంటే ఎంత, 2.5 into 5 హౌ మచ్, 12.5 acres, రైట్? సో మోర్ దాన్ దట్ అయితే దిస్ కమిటీ విల్ సజెస్ట్ వెదర్ దట్ కెన్ బి డైవర్టెడ్ ఆర్ నాట్. బిలో 5 hectares అయితే యూ నీడ్ నాట్ ఆస్క్ దిస్ కమిటీ ఆల్సో ఇన్ దట్ వే. ఓకే, దెన్ యూ హ్యావ్ అనదర్ ప్రొవిజన్ కాల్ accredited compensatory scheme. What is a scheme means, here for example if there is a person A, okay, and he is from Telangana, consider, okay, so this person being a private person, he has grown a land in his 1 acre of area. You can see forest area ni tana 1 acre of land lo penchadu, private forest అనుకోండి. So then there is a company called B. This is a company, this is not an individual. Okay, for establishing their company they have cut down the forest in UP. ఎంత land lo 1 acre land lo వాళ్ళు forest ని కట్ చేశారు. Then according to this scheme what can be done is, this person or this company can buy or they can pay some compensation to this person taking this forest land of 1 acre. అంటే మనకేంటి, ఫారెస్ట్ కన్జర్వేషన్ యాక్ట్లో మెయిన్ ప్రొవిజన్ ఏంటంటే, ఫారెస్ట్ నుంచి నాన్ ఫారెస్ట్ పర్పసెస్కి మనం ఎప్పుడైనా ల్యాండ్ తీసుకున్నప్పుడు యూనో కంపా అనేది ఉంది, కంపెన్సేటరీ ఎఫారెస్టేషన్ అని. అంటే ఎవరు తీసుకున్నారో వాళ్ళు మేము ఇంకొక చోట ఫారెస్ట్ సేమ్ అమౌంట్ ఆఫ్ దాంట్లో పెంచాము అని చూపెట్టాలి. దట్ ఈస్ వాట్ ద మెయిన్ ఆబ్జెక్టివ్. మనం పెంచడం చూపెట్టలేకపోతే అంతకు తగ్గట్టు మనీ ఇవ్వాలి. ఆ ఫారెస్ట్కి ఎంత ఎకనామిక్ వాల్యూ ఉంటుందో అంత మనీ కంపాలోకి డిపాజిట్ చేస్తే గవర్నమెంట్ ఆ డబ్బులతో ఇంకెక్కడైనా ఎఫారెస్టేషన్ చేస్తుంది. దట్ ఈస్ ద మెయిన్ ఆబ్జెక్టివ్. సో ఇక్కడ ఈ పర్సన్ ఏంటంటే, ఇక్కడ 1 acre ఆఫ్ ల్యాండ్, ఫారెస్ట్ ల్యాండ్ తను క్లియర్ చేశాడు కాబట్టి దాని ఈక్వలెంట్గా ఇక్కడ ఈ అతను 1 acre ఆఫ్ ఫారెస్ట్ ల్యాండ్ పెంచాడు కాబట్టి అతనికి కంపెన్సేషన్ మనీ ఇస్తాడు. ఓకే, అప్పుడు ఏమవుతుంది, ఇతను వెళ్ళి గవర్నమెంట్ దగ్గర చూపిస్తాడు నేను ఈ 1 acre ఇక్కడ కంపెన్సేట్ చేశాను అని. బట్ థింక్ అనదర్ థింగ్ ఈస్, ఇన్ కేస్ ఇక్కడ ఇతను కొత్తగా పెంచిన ఫారెస్ట్, ఇక్కడ ఆల్రెడీ ఉన్న ఫారెస్ట్ సేమ్ ఈక్వలెంట్ ఉంటాయా? దీస్ ఆర్ యంగ్ ఫారెస్ట్. వాట్ ఎవర్ ద సర్వీసెస్ దే ప్రొవైడ్ విల్ బి డిఫరెంట్ అండ్ ఓల్డ్ మెచ్యూర్ ఫారెస్ట్ విల్ బి డిఫరెంట్. నో, పెద్ద పెద్ద ట్రీస్ ఉండి కార్బన్ సింక్ విషయంలో దెర్ విల్ బి లాట్ ఆఫ్ థింగ్స్ వేరియేషన్స్ దీంట్లో కూడా ఒక మెయిన్ ఛాలెంజ్ వచ్చింది అనమాట. ఓకే, దెన్ 5 hectare exemption already I told you, below 5 hectares exempted. Then violation of provisions of this FRA we have discussed in the previous class about Forest Rights Act. దాంట్లో నేను చెప్పాను Gram Sabha is having entire powers to determine what type of rights we have discussed, no, individual rights, community rights, resource rights, displacement rights and atla chusam mem. Dantlo who is having the power? Gram Sabha. But here they have violated this provision. They said Gram Sabha is not having any permission in case if you are diverting the forest land in this particular area of scheduled tribes area also. Okay, this is also getting violated. Then they also contravene this judgment of Kodavarmanu. They said ఇక్కడేమో డిక్షనరీ జడ్జ్మెంట్ ఉండాలని సుప్రీంకోర్టు చెప్తే వాళ్ళు ఇప్పుడు కొత్త డెఫినేషన్ ఏం యాడ్ చేశారు గవర్నమెంట్. దే సెడ్ విచ్ ఈస్ లిస్టెడ్ యాజ్ గవర్నమెంట్ రికార్డ్లో ఫారెస్ట్గా ఏది ఉందో అది మాత్రమే అని అన్నారు. ఇట్ ఈస్ క్లియర్ వైలేషన్ ఆఫ్ దిస్ పర్టికులర్ థింగ్. అండ్ అనదర్ థింగ్ ఇస్ ఒకవేళ ఫారెస్ట్ని మనం జూ ఆర్ సఫారీగా కంట్రోల్ చేయాలనుకుంటే రీసెంట్గా సుప్రీంకోర్టు ఏం చెప్పిందంటే మీరు మీ ఇష్ట రాజ్యం కాదు సుప్రీంకోర్టు అప్రూవల్ తీసుకోవాలి అని చెప్పింది. అగైన్ దిస్ ఇస్ సీన్ యాజ్ జుడిషియల్ ఓవర్ రీచ్. ఓకే, సో ఇట్ సెడ్ ఈ డెఫినేషన్స్ అన్ని కుదరవు. గోదావర్మన్లో ఎవరు చెప్పారు మళ్ళీ అది కూడా సుప్రీంకోర్టు చెప్పింది డిక్షనరీ మీనింగ్. సో యూ హ్యావ్ టు టేక్ దట్ డెఫినేషన్ ఓన్లీ ఇన్ కేస్ ఇఫ్ యూ ఆర్ డైవర్టింగ్ ఫారెస్ట్ అండ్ ఇన్ కేస్ ఇఫ్ యూ వాంట్ టు ఎస్టాబ్లిష్ ఎనీ జూ ఆర్ సఫారీ ఆల్సో యూ హ్యావ్ టు టేక్ అప్రూవల్ ఫ్రమ్ Supreme Court. It is not a central government. That is what the Supreme Court judge said in the recent judgment. Okay, in this way this also you can quote as judicial overreach. Okay, clear with this? అర్థమైందా? కన్ఫ్యూజింగ్ ఉందా? ఓకే, మాక్సిమం ఏంటంటే సెంటర్ మిస్యూజ్ చేయకుండా ఫారెస్ట్ని దే ట్రై టు రెస్ట్రిక్ట్. ఓకే, సుప్రీం కోర్ట్ అనేది కొంచెం ఫారెస్ట్ని కాపాడటానికి ఫారెస్ట్ కన్జర్వేషన్లో ఇన్ని ఎగ్జామ్షన్స్ ఇవ్వడం కరెక్ట్ కాదు అని చెప్పి ఇట్ హ్యాస్ గివెన్ ఫారెస్ట్ డెఫినేషన్ అంటే గవర్నమెంట్ రికార్డ్లో కాదు ప్లస్ డిక్షనరీలో ఉన్న మీనింగ్ ప్రకారం ఏదైనా ఫారెస్ట్ అని సుప్రీం కోర్ట్ చెప్పింది. మెయిన్ రీజన్ ఇస్ దట్. ఓకే, క్లియర్? Like in case if you want to compensate forest, you're asking. I'm asking that you want to balance between development and environment. Yes. So sustainable development, that is an easy alternative. Simple. One alternative. Yes or no? So in like you have different things, compensatory afforestation undi, environment impact assessment undi, ivanni environment ni protect chestu development ki unnai kabatti you just advocate these things, that's it. Okay, then triple dip planning, again a issue which will eat your brains, right? Okay, for this you need to understand clearly, be patient. Triple dip planning. Okay, so triple dip means 3 consecutive years నుంచి లానినా ఉంది. ఓకే, బికాస్ ఆఫ్ దిస్ టిల్ నౌ వీ థింక్ మీ అందరికీ ఎవరికి అసలు ఇంతమందిలో ఎవరికి ఫస్ట్ లానినా ఎల్నినా గురించి క్లియర్గా తెలుసు? రైజ్ చేయండి హ్యాండ్స్. క్లియర్గా అంటే అట్లీస్ట్ కొంచెమైనా తెలియదు, అసలు బ్లాంకా? ఎస్, నో వన్ నోస్. ఓకే, ఈజ్ ఎల్ నీనో గుడ్ ఫర్ ఇండియా ఆర్ లానినా గుడ్ ఫర్ ఇండియా? లానినా. ఇది తెలిసిందంటే అది తెలిసే ఉంటుంది, బట్ యూఆర్ నాట్, ఎక్కడ క్వశ్చన్స్ అడుగుతుందో మ్యామ్ అని యూఆర్ నాట్ ఈవెన్ ఆన్సరింగ్. ఎస్ ఆర్ నో, హానెస్ట్లీ. ఓకే, సో ఫర్ దిస్ to understand some basic geography you need to know. I expect that you know that geography. We'll understand what is El Nino, La Nina first, and then we'll understand what is this impact of La Nina on Indian climate, which was found in the recent study. Okay, so first thing you need to know is normally equator you know, and you have Tropic of Cancer, Tropic of Capricorn. So sun anytime will not cross over this region, right? Beyond this sun doesn't go. Okay, so that means this is a region, tropics you know, which receives maximum insolation, so maximum heat means maximum warm air will be there. Warm air means more evaporation, condensation again precipitation. This is a basic thing you know, right? Okay, then come to here. So here you have ఇది North America అనుకుందాం. Okay, NAM for time being. Okay, this side you have Australia. Okay, here you have Southern America you think. So this is Eastern Pacific antam, and you have here Western Pacific. Okay, Australia ante ikkada India undi anukundam for example. Okay, then what happens is normally in this situation, you know, trade winds, you know, global wind pattern, right? Tells kada adi kuda telida. Fine, you have different types of winds, no? Here you have trade winds. Okay, these are northeast trade winds, southeast trade winds. You have westerlies, you have polar easterlies, same way in the southern hemisphere also. That means in this region of tropics you have trade winds. Trade winds or easterlies, they blow from eastern direction to western direction. Yes or no? The name in geography we name after the wind the direction in which it flow. Okay, northeast నుంచి వచ్చేవి northeast trade winds, southern hemisphere లో southeast direction నుంచి వస్తాయి west వైపు. So then what happens is here this is east and this is west, no? Okay, better I'll draw other way. So let it this be western Pacific. అంటే ఇక్కడ ఆస్ట్రేలియా ఉంది అనుకుందాం. Okay, this is eastern Pacific. You have North America here, NAM, and you have Southern America here, that is Peru coast. Okay, so here what happens is trade winds will be flowing from east to west, no? That means ila ravali kada. Okay, that means when they are moving, what they'll do, they'll carry the ocean currents also along with this, no? So here warm ocean currents will be there. Those will be carried from the eastern direction to the western direction in normal situation by these trade winds. That means ikkadiki warm ocean current settle ayindi ante warmness ki associated ga em untundi, ikkada drought untunda, rainfall untunda? Rainfall ఇప్పుడు అదే కదా నేను చెప్పింది. ఎక్కడైనా మనకి ఎక్కువ ఎవాపరేషన్ జరిగిందంటే క్లౌడ్స్ ఎక్కువ ఫామ్ అవుతాయి, ప్రెసిపిటేషన్ ఎక్కువ జరుగుతుంది కదా. అంటే ఇక్కడ వార్మ్నెస్ ఉందంటే ఈ పార్ట్ నార్మల్ సిచ్యువేషన్స్లో ఆస్ట్రేలియా, ఇండియా ఇక్కడ ఉందనుకుంటే రెయిన్ఫాల్ ఉంటుంది. అదర్ సైడ్ ఏముంటుంది, ఇక్కడ డ్రాట్ ఉంటుంది. ఎస్ ఆర్ నో? ఓకే, దట్ మీన్స్ దట్ ఈస్ వై యూ హ్యావ్ అటకామా డెజర్ట్ హియర్. కోల్డ్ ఓషన్ కరెంట్ ఉండడం వల్ల నార్మల్ సిచ్యువేషన్. ఇక్కడ వార్మ్ కరెంట్ ఉందంటే ఇక్కడ కోల్డ్ కరెంట్ ఉంటుంది కదా, ఆపోజిట్సే కదా మీకు జనరల్గా తెలియాల్సింది. సో ఇక్కడ డ్రాట్ ఉంటుంది, ఇది నార్మల్ సిచ్యువేషన్. బట్ సమ్ టైమ్స్ వాట్ హ్యాపన్స్ ఈస్ అగైన్ ఇది వెస్టర్న్ పెసిఫిక్ అనుకోండి, ఈస్టర్న్ పెసిఫిక్. హియర్ యూ హ్యావ్ ఆస్ట్రేలియా, హియర్ యూ హ్యావ్ సౌత్ అమెరికా. సో ఇక్కడ ట్రేడ్ విన్స్ ఏంటంటే ఎప్పుడు నార్మల్గా ఉన్నప్పుడు దే క్యారీ ఫ్రమ్ ఈస్ట్ టు వెస్ట్. బట్ ఇన్ సమ్ పార్ట్స్ ఆఫ్ ఎ ఇయర్ ఆర్ సమ్ మంత్స్ ఆఫ్ ఎన్ ఇయర్ trade winds will become weak. Okay, when trade winds are weak, they don't push this warm ocean current from the eastern side to the western side. What happens as a result? So this warm ocean current will flow towards Peru coast. Okay, appudu em avutundi, if this warm ocean current settles here it will be rains, right? And here the opposite will be the drought, and it is completely getting reversed here. But in case of La Nina, here these trade winds become hyperactive, like you people in the class. Okay, then what happened? Trade winds will push warm ocean current, plus at the same time more warmness untundam valla em avutundante మీకు జనరల్ గా ఈ టైం కి La Nina time లో ఓషన్ పెసిఫిక్ ఓషన్, యు నో దట్ ఈస్ ద లార్జెస్ట్ ఓషన్ కదా. సో డీపెస్ట్ పార్ట్ ఆఫ్ ద ఓషన్ కోల్డ్ గా ఉంటుంది జనరల్గా, అంతే కదా, సన్లైట్ ఉండదు కాబట్టి కోల్డ్గా ఉంటుంది, సర్ఫేస్ అనేది వామ్గా ఉంటుంది. సో ఎప్పుడైతే ఈ వామ్ ఓషన్ కరెంట్ ఇక్కడి నుంచి ఇక్కడికి పుష్ చేయబడిందో అప్పుడు ఏమవుతుంది, ఈ కోల్డ్ వాటర్ ఏవైతే ఉన్నాయో అవి సర్ఫేస్కి రావడానికి ట్రై చేస్తుంది. జనరల్గా కన్వెక్షన్ థియరీ అదే కదా. సో ఇక్కడికి వామ్ ఓషన్ కరెంట్ రాగానే ఇక్కడికి కోల్డ్ ఓషన్ కరెంట్ వెళ్తుంది దాని ప్లేస్ను ఆక్యుపై చేయడానికి. సో మళ్ళీ ఇక్కడ లానినా టైంలో ఇన్ నార్మల్ సిచ్యువేషన్స్ కంటే ఎక్కువ రెయిన్ఫాల్ ఉంటుంది. దట్ ఈస్ వాట్ లానినా. Okay, in La Nina we have above average rainfall. El Nino lo manaki less than average rainfall untundi, ikkada average rainfall untundi. This is what how it operates. Briefly I have explained. But now for this to understand ఏమైందంటే ఇప్పటి వరకు మనకి జస్ట్ La Nina ఇవన్నీ జస్ట్ rainfall ని డిటర్మైన్ చేస్తాయి, లేదంటే డ్రాట్ ఆర్ దీన్ని మాత్రమే డిటర్మైన్ చేస్తాయి, క్లైమేట్ ని మాత్రమే డిటర్మైన్ చేస్తాయి అని ఇప్పటి వరకు మనకు ఉన్న ఐడియా. బట్ ఇన్ ద రీసెంట్ స్టడీ మేడ్ బై వన్ ఆర్గనైజేషన్ in India, what did they identified is in 2022, okay, పొల్యూషన్ ఎలా ఉంది అనేది నార్మల్గా మనం డిఫరెంట్ ఫ్యాక్టర్స్ మీద డిటర్మైన్ చేస్తాం, అవునా కదా. వెహికులర్ ఎగ్జాస్ట్ కానీ, స్టబల్ బర్నింగ్ కానీ, లేకపోతే డిఫరెంట్ కన్స్ట్రక్షన్ డస్ట్, యూనో ఫైర్ క్రాకర్స్ కానీ, ఇవన్నీ డిఫరెంట్ పారామీటర్స్. సో యూనో ఇన్ ఇండియా వెన్ యూ లిజన్ అబౌట్ ఆర్ వెన్ యూ హర్డ్ అబౌట్ ఎనీ వర్డ్ అబౌట్ పొల్యూషన్, సిటీ యూ రిమెంబర్ ఇమీడియట్లీ Delhi, which is considered as gas chamber of India, no? Entire world also it is becoming the most polluted capital of the world. Yes or no? So what happens is, normal situations లో winter లో నార్దర్న్ ఇండియన్ సిటీస్ ఎక్కువ పొల్యూటెడ్ గా ఉంటాయి, సదర్న్ ఇండియన్ సిటీస్ విల్ హ్యావ్ లెస్ పొల్యూషన్. ఎందుకు అంటే వింటర్లో ఏమవుతుంది, మీకు ఎప్పుడైనా గాలి మూవ్మెంట్ ఎక్కువ ఉంటుందా తక్కువ ఉంటుందా? వింటర్లో తక్కువ ఉంటుంది. విండ్స్ ఎప్పుడు ఎక్కువ ఉన్నా అప్పుడు ఈ పార్టికులేట్ మ్యాటర్స్ పొల్యూటెంట్స్ని క్యారీ చేస్తాయి ఈజీగా. విండ్ మూమెంట్ తక్కువ ఉందంటే ఆ పార్టికులేట్ పొల్యూటెంట్స్ అక్కడే ఉంటాయి, దే డోంట్ మూవ్, అందుకని పొల్యూషన్ ఎక్కువ అవుతుంది. సింపుల్ లాజిక్ అక్కడ. కానీ సదర్న్ ఇండియన్ స్టేట్స్లో మనకి ఎందుకు పొల్యూషన్ తక్కువ ఉంటుందంటే మనకి ఓషన్ ఉంది చుట్టూ. సో ఓషన్లో ఎప్పుడైనా మనకి బ్రీజెస్ ఉంటాయి కాబట్టి ఆటోమేటిక్గా మన ఎయిర్ అనేది ఫ్లో అవుతుంటుంది, క్లియర్ అయిపోతుంది పొల్యూషన్. బట్ ఫర్ ద ఫస్ట్ టైం ఈ స్టడీలో వాళ్ళు ఐడెంటిఫై చేసింది ఏంటంటే లానినా ఇంపాక్ట్ వల్ల ఢిల్లీ నార్దర్న్ సిటీస్లో క్లీన్నెస్ పొల్యూషన్ లెవెల్ తక్కువ ఉంది, సదర్న్ స్టేట్స్లో ఎక్కువ ఉంది అని. ఓకే, అర్థమవుతుందా? నార్మల్ సిచ్యువేషన్లో ఢిల్లీ నార్దర్న్ ప్లేసెస్ ఎక్కువ పొల్యూటెడ్గా ఉంటాయి, సదర్న్ ప్లేసెస్ క్లీన్గా ఉంటాయి. అంటే మరి కంపారిటివ్గా కంప్లీట్ క్లీన్ అన్నట్లేదు, ఎందుకంటే ఇవి ఇంటీరియర్లో ఉన్నాయి, ఇవి ఓషన్కి ఉన్నాయి, మనకి క్లియర్ విండ్ ఫ్లో అనేది ఎక్కువ ఉంటుంది. బట్ ఈ రీసెర్చ్లో వాళ్ళు ఐడెంటిఫై చేసింది ఏంటంటే లానినా వల్ల దెర్ ఇస్ డైరెక్షన్ ఇన్ ద విండ్స్ ఆల్సో. డైరెక్షన్ అంటే ఫస్ట్ టైం ఏంటంటే మనకి నార్త్ వెస్టర్లీస్ ఫ్లో అవుతాయి మనకి నార్దర్న్ ఇండియాలో. నార్త్ వెస్టర్లీ విండ్స్ డైరెక్షన్ చేంజ్ చేసుకుని నార్త్ టు సౌత్ వెళ్తున్నాయి. నార్త్ వెస్టర్లీ వెళ్ళాల్సిన విండ్, నార్త్ వెస్టర్లీ అంటే ఏంటి, ఇది కదా డైరెక్షన్ నార్త్ వెస్టర్లీ. ఇలా వెళ్ళాల్సిన విండ్ అంటే ఇట్లా వెళ్ళాల్సిన విండ్, నార్త్ సౌత్ అంటే ఇది కదా డైరెక్షన్. అంటే నార్త్ ఇండియాలో ఉన్న పొల్యూటెంట్స్ని తీసుకుని అవి ఎక్కడికి వస్తున్నాయి, సదర్న్ ఇండియాకి వస్తున్నాయి. ఈ చేంజ్ ఎందుకు వచ్చింది నార్త్ వెస్ట్ నుంచి నార్త్ సౌత్ డైరెక్షన్ విండ్ చేంజ్ ఎందుకు అయింది అంటే బికాస్ ఆఫ్ లానినా. దట్ ఈస్ వాట్ ఐడెంటిఫైడ్ బై దిస్ స్టడీ. ఓకే, డిడ్ యూ అండర్స్టాండ్ నౌ? This is what identified. So you can see triggered a peculiar trend. That means they have reversed abnormal situations kanukunnar. What happened in 3 consecutive years of La Nina? We have between 2020 to 2023. That is why we have heavy flooding in different parts of India. But now we are experiencing El Nino. Okay, so we may not have expected rainfall in the future year. You can say air quality improved in northern India, while peninsular India recorded increase in the pollution. Why? Because this winds have changed their direction. That direction change happened due to La Nina. That is what identified by this study. Clear? Here you can understand. So I just told you, this is in normal situations I told you, right? In abnormal situations like El Nino, this will be slowly moving because there are no trade winds, no? So they will move slowly and they'll come to the center and they slowly move to the eastern side. But in La Nina situations, they will come more rigorously and they'll have extra rainfall here. So this is what I explained here. You can see in normal situations, there will be equator and the sun will have in the tropics level. That is why low pressure will be generated. Low pressure is associated with warmness, right? Yes or no? High pressure is associated with dry conditions or cold conditions. So high pressure system will develop over the coast of Peru. Under normal situations, ikkada drought untundi. Australian coast or Indonesian coast lo rainfall untundi. Normal situations. Then you can see, because trade winds will blow strongly from east to west, they'll transport this warm surface waters to the western side, because of which we have this normal convective rainfall on the coast of Australia, and the Peru coast will experience drought. This is a normal situation. Then El Nino and La Nina, I told you, these are opposite. Means, for example, if El Nino is at the Australian coast, La Nina will be at the Peru coast. Ante kada? If La Nina is at the Australian coast, El Nino will be at the Peru coast. So in this reverse case it happens. Okay, ఇప్పటి వరకు 2020 నుంచి 2023 వరకు మనకి La Nina ఉంది, అంటే పెరువియన్ కోస్ట్లో El Nino ఉంది. బట్ దీస్ టూ గెట్స్ చేంజ్డ్ ఒక 3 to 5 years or 7 years టైంలో చేంజ్ అవుతుంటాయి. సో ఇప్పుడు మనకి El Nino కండిషన్స్ స్టార్ట్ అయితే ఆల్మోస్ట్ ఫర్ 3 to 5 years or 7 years El Nino ఎక్స్పీరియన్స్ దాని ఇంపాక్ట్స్ అనేవి ఇండియన్ వెదర్ మీద ఉంటాయి. అంటే వీ హ్యావ్ రెడ్యూస్డ్ రెయిన్ఫాల్స్, బిలో యావరేజ్ రెయిన్ఫాల్స్ ఉంటాయి ఇండియాలో. Okay, that is a basic thing you need to know. El Nino is warm phase, from west to east they move, east to west both. Endukante trade winds weak ga unnai kabatti there won't be movement. Then you can see La Nina is a cold phase, reverse thing happens, more stronger winds we have. El Nino and La Nina will have global effects on the weather. Impact of La Nina, if you see, National Institute for Advanced Studies in Bangalore and National Institute for Tropical Meteorology in Pune. these two institutes have conducted, and they found that there is a relation between pollution level and La Nina presence. That is what identified by this study. Okay, as I told you, monsoon rainfall over in India is strongly influenced by El Nino and La Nina. Okay, El Nino appudu takkuva rainfall, La Nina appudu ekku untundi. First time we identified that air quality is also linked to La Nina event, which is indirectly linked with climate change. So here you can see PM 2.5, particulate matter 2.5 తెలుసు కదా మీకు, మనకు చాలా స్మాల్ ఉంటుంది, ఈవెన్ లెస్ దాన్ హెయిర్ మాలిక్యూల్ సైజ్ ఉంటే తక్కువ ఉంటుంది. అలాంటివన్నీ విండ్ మూమెంట్లోనే ట్రాన్స్పోర్ట్ అవుతాయి అనమాట. వింటర్లో ఎందుకు ఎక్కువ ఉంటాయి PM 2.5 అంటే విండ్ మూమెంట్ ఎక్కువ ఉండదు కాబట్టి. బట్ what happened is northern Indian cities including Delhi were found cleaner than usual in 2022 winter, but peninsular cities like Mumbai, Bengaluru, Chennai, they experienced worse than usual air quality because of La Nina. This direction change in winds happened due to La Nina impact. Okay, so this is what I told you. PM 2.5 10% తగ్గింది ఢిల్లీలో, but southern states like Bengaluru 20% increase అయింది PM 2.5 level. It was not at clearly very clear that El Nino can produce the opposite result. అంటే ఒకవేళ La Nina ఉన్నప్పుడు సదర్న్ స్టేట్స్ ఎక్కువ ఉన్నాయి కాబట్టి El Nino అప్పుడు మళ్ళీ నార్త్ ఇండియాలో పొల్యూషన్ ఎక్కువ అవుతుందా అనేది ఇంకా ప్రూవ్ అని అవ్వలేదు స్టడీలో. దే ఆర్ స్టడీయింగ్ అబౌట్ దిస్. సో హౌ La Nina impacted is by changing the wind direction is one, and by changing the local circulation of wind near Mumbai. Near Mumbai what happened is, you know, normally land and sea breeze will be there, no? During the day, which will be there? Simple, ma land breeze, sea breeze చదివారా లేదా వరల్డ్ జాగ్రఫీలో? చదవలేదు. ఏం చదవలేదు? ABCనా? అది కూడా చదవలేదా? See, basic thing you need to know is air, wind will move from హై ప్రెషర్ టు లో ప్రెషర్ కదా, ఇది బేసిక్ తెలుసు కదా. సరే, ఇప్పుడు ల్యాండ్ బ్రీజ్ సీ బ్రీజ్ అనే దానికి మనం ఫస్ట్ ఎట్లా అర్థం చేసుకుందామంటే డే టైంలో ఓకే, ల్యాండ్ ఎక్కువ హీట్ అవుతుందా, సీ ఎక్కువ హీట్ అవుతుందా? ల్యాండ్ డే టైం. ఓకే, డే టైంలో ల్యాండ్ ఎక్కువ హీట్ అవుతుందంటే ఇప్పుడు ఎక్కువ లో ప్రెషర్ ఎక్కడ ఉంటుంది, ఎక్కువ హై ప్రెషర్ ఎక్కువ ఉంటుంది? సీ హ్యాస్ హై ప్రెషర్ అండ్ ల్యాండ్ హ్యాస్ లో ప్రెషర్ కదా. అంటే ఇప్పుడు డే టైంలో సీ నుంచి ల్యాండ్కి వస్తుందా విండ్, ల్యాండ్ నుంచి సీకి వెళ్తుందా? సీ నుంచి ల్యాండ్కి వస్తుంది. సీ నుంచి ల్యాండ్కి వస్తుందంటే దాన్ని ఏమంటాం? సీ బ్రీజ్ అంటాం. అంటే డే టైంలో సీ బ్రీజ్ ఫామ్ అవుతుంది. అంటే డే టైంలో సీ నుంచి ల్యాండ్ వైపు విండ్స్ వస్తాయి. సీ బ్రీజ్ అంటే అంతే, అంతకు మించి ఏం లేదు, టెక్నికల్ టర్మ్స్ ఏం లేవు అక్కడ. నైట్ టైం అవుతుంది, ల్యాండ్ నుంచి సీకి వెళ్తుంది. దట్ ఈస్ వాట్. ఓకే, ఈ డైరెక్షన్ అనేది చేంజ్ అయింది La Nina వల్ల. అలాంటివి యూజువల్ థింగ్స్ ముంబై కోస్ట్ నుంచి ముంబై సిటీకి ఇట్లా మారేవి కూడా అబ్నార్మల్గా బిహేవ్ చేశాయి La Nina వల్ల. దట్ ఈస్ వాట్ దే ఫౌండ్ ఇన్ ద స్టడీ. క్లియర్? దెన్ సరోగసీ. ఓకే, అగైన్ another important topic. Why it is in news? Because if you have seen yesterday itself, center has given new rules for surrogacy. Okay, what is surrogacy? They could tell you, huh? Why you people are behaving abnormally today? ఆకలేస్తుందా, నిద్ర వస్తుందా, ఏడుపు వస్తుందా, ఏం అర్థం కాక? ఇది బెటర్ వర్డ్ కదా. See, surrogacy means, okay fine, so normally you know male and female, okay, so male నుంచి sperm, female నుంచి egg, వీటిని ఏమంటాం? గ్యామెట్స్ అంటాం. ఓకే, ఇవి రెండు ఫర్టిలైజ్ అయితేనే జైగోట్, దాని నుంచి ఫీటస్లో బేబీ ఫామ్ అయ్యి బేబీ బయటకు వస్తుంది కదా, అవునా కదా? ఇది సరోగసీలో నార్మల్గా జరిగేది. బట్ ఇన్ కేస్ ఇఫ్ దిస్ మేల్ ఈస్ హ్యావింగ్ సమ్ స్పర్మ్ కౌంట్ తక్కువ ఉన్నా, ఆర్ ఇట్ ఈస్ నాట్ ఏబుల్ టు రిప్రొడ్యూస్, ఆర్ ఫీమేల్ ఎగ్ ప్రొడక్షన్ సరిగ్గా లేకపోయినా, ఫీమేల్ యూటరస్, ఎందుకంటే యూటరస్లోనే కదా చైల్డ్ పెరిగేది, యూటరస్ వీక్గా ఉండి కొంతమందికి తీసేస్తారు, ఎందుకంటే ట్యూబ్స్ వస్తాయి, ఫైలోపియన్ ట్యూబ్లో మనకి కొన్ని వస్తుంటాయి అనమాట, లైక్ వాటర్ బబుల్స్ లాంటివి, ఫిస్టస్ లాంటివి వస్తుంటాయి. సో దానివల్ల ఏమవుతుంది, యూటరస్ మొత్తం తీసేయాల్సి వస్తుంది. జనరల్గా యూటరస్ తీసేసేటప్పుడు ఆ ఉమెన్ ఏజ్ ఎంత, చిల్డ్రన్ ఉన్నారా లేదా అని చూస్తారు. ఎందుకంటే దాన్ని ఒకవేళ రిప్రొడక్టివ్ ఏజ్లో ఉండి చిల్డ్రన్ కావాల్సి ఉన్న వాళ్ళు అంటే కనుక జనరల్ యూటరస్ తీసేరు ఆ టైంలో, ఎందుకంటే యూటరస్ లేకపోతే యూ కెనాట్ గివ్ బర్త్ టు అనదర్ వన్. ఓకే, సో ఇన్ దట్ వే. బట్ ఫీమేల్కి కూడా కొన్ని హెల్త్ కండిషన్స్ వల్ల ఇఫ్ షీ ఈస్ నాట్ సపోర్టివ్ ఫర్ రిప్రొడక్షన్, దెన్ వాట్ హ్యాపెన్స్, ఈయనలో ప్రాబ్లం ఉంటే, ఓకే, వాట్ దిస్ పర్సన్స్ ఆర్ దిస్ ఉమెన్స్ ఎగ్ విల్ బి టేకెన్ అండ్ డోనర్ స్పర్మ్ విల్ బి టేకెన్. ఓకే, ఆర్టిఫిషియల్గా ల్యాబ్లో ఫర్టిలైజ్ చేసి మళ్ళీ మదర్స్ హోమ్లో పెడతారు. దట్ కెన్ బి డన్. ఓకే, బట్ ఇన్ కేస్ ఇఫ్ ది మదర్ ఇట్ సెల్ఫ్ ఆర్ ద ఫీమేల్ పర్సన్ ఇట్ సెల్ఫ్ ఇస్ హ్యావింగ్ సమ్ ప్రాబ్లమ్ ఇన్ ఎగ్ కౌంట్ ఆర్ యూటరస్, దెన్ వాట్ హ్యాస్ టు బి డన్, ఈ మేల్ పర్సన్ నుంచి స్పర్మ్ తీసుకుని, ఇన్ కేస్ ఇఫ్ షీఈస్ హ్యావింగ్ ఎగ్ కౌంట్ బట్ యూటరస్ ప్రాబ్లమ్ ఉందనుకుందాం, దెన్ ఈ దగ్గర నుంచి ఎగ్ తీసుకుంటారు. అంటే ఎవరైతే వైఫ్ అండ్ హస్బెండ్ ఉన్నారో వాళ్ళ దగ్గర నుంచి స్పర్మ్ అండ్ ఎగ్ తీసుకుని ఆర్టిఫిషియల్గా ల్యాబ్ ఐవీఎఫ్లో దాన్ని ఫర్టిలైజ్ చేసి, ఈ మదర్కి యూటరస్ సపోర్ట్ లేదు కాబట్టి ఇంకొక ఉమెన్ ఎవరైతే విల్లింగ్గా ఉన్నారో టు క్యారీ ద చైల్డ్ ఇన్ దేర్ యూటరస్, వాళ్ళ యూటరస్లో పెంచుతారు. దాన్ని సరోగసి అంటాం, అద్దె గర్భం అంటాం, అంతే. ఓకే, ఓకే, fine. If this female is not having uterus, okay, then this male's sperm and this female's egg, they will be taken and fertilized in artificially in a lab. Then it will be placed in some another woman's womb who is ready to go for this delivery. Okay, that mother is called third woman is there, no, in this, she will be called as surrogate mother. Okay, so why this issue has become very prominent, because you know in India most of the poor women, okay, they are subjected to surrogacy because foreigners are coming here, they are paying the poor women and they are taking their child. Okay, so it is not that easy, because if a woman repeatedly undergoes surrogacy, or repeatedly if she undergoes reproduction and all, there will be definitely an impact on the health of the woman also, no. For 10,000 or 20,000 that undergoing surrogacies, it is going to impact the woman. But at the same time, see, after bearing a child for 9 months, okay, so she'll have some emotional connect also with the child, no, although biological mother kaakapoina, she'll have some emotional connect, right? So then she has to face some problems also psychologically of leaving the child to the parents and all. So that is also creating some troubles. That is why, to ban all these things, government has brought Surrogacy Regulation Act. Okay, and in the recent times it has brought some rules also. What is allowed is surrogacy, 2 types of surrogacies we have. Okay, one is commercial surrogacy and altruistic surrogacy. 2 things we have. Commercial surrogacy means if the mother, biological mother and surrogate mother, okay, if they are not related to each other anyhow, but just for money, if she is undergoing surrogacy, that surrogate mother means she taking money like for 10,000 or 20,000, she is ready to carry some other person's child in her womb, then you call it as commercial surrogacy. So this is not previously allowed. Okay, there is no law at that time, people got misused these provisions and all. But now when this act was passed in 2017, government has banned commercial surrogacy. That means in the name of money you cannot ask any woman to become a surrogate mother. Okay, but what did they allow? Altruistic surrogacy. That means if that woman, biological mother and the surrogate woman, if they're closely related to each other, ante blood relatives like sisters or some other way, if they're related to them, then they can become surrogate mother for that. Altruistic means there should not be any involvement of money. The surrogate mother should not be paid anyway, but by blood relation or some relation, she can become the surrogate mother. Just being like soft cornered and because of sympathy, she can go for surrogacy. But again, they have mentioned some conditions, like the woman already who is undergoing surrogacy, she should have already 1 child of her own. If she is not having any child of her own, then she'll automatically have that emotional connect, no. Okay, she cannot leave that child. So this is one condition they have placed, and they have placed age limits also, like women between 26 to 50 years of age and men from 30 to 55 years of age. Between this age bracket only, if they fall, they can undergo for surrogacy, provided that they should be medical conditions with the men or female, both the wife and husband, anyone should have some medical problem, and that medical problem has to be attested by district medical board. They should issue a certificate that these couple cannot have any other alternative means of reproduction except surrogacy. Okay, if they certify, then only they can undergo for altruistic surrogacy but not commercial surrogacy. Ardhamavutunda? Okay, some conditions are given because women are being subjected to surrogacy for money reasons. Okay, if you have seen famous Nayanthara, you have Vignesh, those persons also within less than 1 year of marriage, how did they have their twin babies? Again surrogacy. Priyanka Chopra surrogacy. Amir Khan, even Shah Rukh Khan's one of the boy, I think, he is also out of surrogacy. Karan Johar, he openly declared himself as a gay, but how did he have children? Again surrogacy. Okay, so many persons are there. So we are seeing in the recent times only. So surrogacy has become one of the thing which the poor are becoming vulnerable. Okay, so poor women are getting exploited in the name of surrogacy. To prevent all these things, center has brought new laws. But why we are discussing this issue is, this was brought, all what we have discussed was brought as part of a law in 2017. But what happened in 2022 is, 2017 law తీసుకొచ్చే ముందు, like before that law, a woman, she doesn't have supportive egg count, okay, in some part of India, but her husband is okay. Then what she have to do to have a child? Some others woman's egg has to be taken in, that has to be fertilized with the husband's sperm or no. So she has undergone that therapy or something. Okay, now the zygote is there and she wants to carry in her uterus. She doesn't have any problem in uterus, but there is low egg count. Okay, so then what happened? That at that point of time when this process is going on, center has brought this particular law, surrogacy, 2017 law. And you know, in India normally laws cannot be applied retrospective. Yes or no? So, but when this woman has to undergo the procedure and all medical treatment, then that particular medical college, they have declined this process, because in that provision of central law which was brought at that time, they did not allow any donor based surrogacy. That means surrogacy in 2017 is only allowed only if male and female both have contributed their sperm and egg. If there is any donor sperm or donor egg, that will not be valid. Okay, but this woman already have undergone the procedure even before the act was brought. That is why she challenged this decision of the central government and she went to Supreme Court. Okay, before that law only I started this procedure, then how you can how you can ask me to not undergo this procedure and all? In that way, this case went to Supreme Court. Supreme Court then said you cannot restrict. Okay, she is not having egg count, then she cannot become mother on her own. Yes or no? So then how you can make her or how you can restrict the reproductive choice of the woman? Because reproductive choice is also her right to life and personal liberty, Article 21. So how you can restrict it? That is what Supreme Court has directed center at that time. Center has been asked by the Supreme Court to bring new guidelines or new rules, even to allow donor sperm or donor egg also, and that can be undergone surrogacy. Okay. Now, yesterday itself, that is what appeared in today's newspapers also, center, in the light of that judgment, it has issued or it has amended the surrogacy regulation rules to allow use of donor gamete. Means, in case intak mundu varaku, I am again simplifying this, before 2017, when this act was passed, only male and female who are wedded or the couple is there, their sperm or egg only that can be given under surrogacy. Okay, there is, in case if there is a defect in male or female, that cannot be merged with another one. That is what the main restriction is. But now, in case if this male is having some problem, this female can take the help of donor, sperm donor. Okay, Mr. Shetty, Polishetty cinema చూడలేదు ఎవరు, దాంట్లో అదే కదా కాన్సెప్ట్, sperm donor. Okay, same way, if this female is having some problem, this male can take the help of egg donor. Okay, they can get these two things combined and they can have zygote form. Now, this was allowed by the central government by issuing new rules and guidelines. Clear? God should know. Okay, so now it is agreeing to give the child that the person also can have this after their birth. Okay, that means with third party involvement is also now officially allowed. Previously it was not allowed. Okay, this is what I told you. Commercial and altruistic. Commercial means monetary benefit will be given to the mother who is carrying the child. This is not allowed in India. It is completely banned. You cannot give money for surrogacy now. Okay, so altruistic is only allowed. That means no monetary compensation will be paid. Only for emotional connect you can undergo surrogacy in case if you want, right? Then surrogacy in India, I told you what is the reason is why this act was passed is mainly because so many poor women are subjected repeatedly to surrogacy and all. So what are the key provisions of this is Only surrogacy is allowed in these situations. If intending couple suffers from any proven infertility. Previously in 2020, you can see here couples means both, if okay, if anyone is not having problem also, they cannot go for donor based. Okay, if they have male and female egg and sperm, then only they can go for this surrogacy. That is one provision. Altruistic is only allowed. I told you, without any money consideration, she has to undergo surrogacy. Then not for commercial purpose. No commercial surrogacy. Not for producing children for sale, prostitution or exploitation. You know, some children, they'll give birth and they'll sell off the children when they're poor and all, no? So in the name of money, so that cannot be done. And for any other condition or disease specified through this regulation. That means another condition mentioned is, as I told you already, if there is one child, for second child you cannot ask any person to undergo surrogacy. But in case if the first child itself is suffering from any mental and physical abnormalities, and if the survival of the child is itself is in question, okay, and the first child undi aa child kun chanipotaro ledo ane question mark unnappudu second child kosam surrogacy ku vellochu. That is one exemption they have given. Okay, so they have also established under Surrogacy Regulation Act 2 boards, national, state surrogacy boards were there to regulate, because you know we have seen Yashoda movie, no, that is what the concept of surrogacy, no, so they're exploiting the women. So to regulate these type of things, national level one board and state level another board was established in terms of surrogacy. Offences and penalties were mentioned here. Okay, so in case of any provisions or breach, these type of penalties will be imposed. Okay, so almost a penalty of 10 years punishment and 10 lakh rupees also can be imposed under this Surrogacy Act. Okay, then we have some short things only, just stay for 5-10 minutes. Raising a dialogue, you know, recently it is happening in the recent, because this annual, you can say, geopolitical and geo-strategic summit that is organized by Indian External Affairs Ministry along with Observer Research Foundation. Okay, so this is an NGO, so they together organize this, that is becoming a, like you can say, a stage for discussing different geopolitics and geoeconomic interests. So this is what, nothing but this type of dialogues we have. Shangri-La dialogue that happens in Singapore, if you remember. Like this is an informal dialogue only. But in this context, you know, Greece Prime Minister is the chief guest to this. Okay, and in this light only he said this international Middle East economic corridor should also be lifted up. That is what the statement he made in the recent time. Okay, just remember this. Then it happens in Delhi almost in every month. February it happens. So you know, this year theme is Chaturanga, conflict, contest, cooperation and create. This is what the theme they have adopted, and you can see these are the areas on which they are going to discuss. Okay, no need to remember, just to go through this. Then what is the significance? So different political, geopolitical issues which are troubling the entire globe can be discussed in this particular, as part of this dialogue. So it promotes South-South cooperation. You are seeing in the recent times, North versus South, global South, global North. So this context, different regions and the problems can also be settled. So what are the challenges we have and how to solve these things can be discussed as part of raising a dialogue. Okay, so if there is any major intervention that you can remember, otherwise it is not so important. Then ST tag for mighties. So if you have remembered, all this started with this particular issue only. When this High Court said whether this ST tag can be given for mighties or not, with that only entire Manipur violence started, right? Okay, so for this to understand, you need to know who are mighties. Okay, so these are the people who live in Imphal Valley. You know, Imphal is the capital of Manipur. Okay, so Manipur has some hill areas and some valley region. Valley means normally below the hill region you have, no? So some people like Kuki tribes, Nagas, these are living in the hilly areas. Okay, and they almost occupy only 10% of the population, but still they are living almost on 90% of the area. Okay, and these people, Mighty says that these Kuki people are foreigners, means non-native people. They have come and they have like settled over here, and they are getting more rights. And we being the indigenous people or to the particular land, we are only confined to 10% of the land, while we are 90% of the population. That means these two are fighting for their rights. So when the High Court said these Mighties, okay, as they're suffering some problems, they can be given ST tag or not. When that was examined, then only this issue entirely was broke out between Kukis and Mighties that led to entire Manipur violence. We have seen how many months, how it happened in all. Last year from March, entirely Manipur was under tension, right? So all this is just started there. But now what happened? Bench of Manipur High Court on, recently they said they want to remove this provision of granting ST status for mighties. That was actually proposed by High Court only. From then this tension was started. So now they said just because of this proposal only all this tension started. That is why we wanted to withdraw this paragraph. That is what the High Court said. Okay. So with this removal, what happens? It will simplify. Then here you need to understand the state of Nagaland. Here you have Manipur and you have Mizoram. Okay. All these are having border with Myanmar. This is Manipur. So Imphal here. So in the middle area, these people, Meiteis, will live in the valley region. Around this you have hilly region where Kukis and Nagas will live. Okay. So here you need to understand. Manipur means you have to remember what is this? Cable Lamjawo National Park, which is the only world's floating national park. Okay. You call this floating landmass as Fumdis. Okay. So this is what Shanghai or dancing deer we call. So this when it is walking, it will be floating, no? It appears like it is dancing. That is why we call this as dancing deer. This is the only world's floating national park. These will be floating Fumdis. Okay. So that is, you have to remember, this is also in Manipur. So now what is behind this violence? As I told you, High Court's order of granting ST status for mighties that started this Manipur violence. Okay. So you can see here that started when they wanted to give this to non-tribal mighty. Okay. So Kukis and Nagas are considered as tribals, but these people did not have ST status. That is what they're demanding for. So you can see here. So this is what I told you. In this green region, Imphal Valley, these people are living. In other parts, Kukis, you can see in the hill regions. Browner means green regions. Okay. So in brown regions, hilly areas, these people are living. So this is larger area, but they're very less in population. This is very small area, huge population. So they're asking for their rights. This has led to the protest. So it started with a march of some particular organization in Manipur. So from then it started, violent clashes broke down and all. You can see how this contributed means, you can say, I told you already, 10% of Manipur landmass is dominated by non-tribal mighty, but they're 90% in population. Okay. So almost 40 years onwards, they have 40% of the 60 MLAs are from this particular area only of Imphal Valley. So they're asking for their rights. 90% of area, and it is occupied by 35% of recognized tribes, like you can say Nagas, Kukis, all these people. So that is why how we demanded. So now these are demanding status for this mighty people. And you know, mighties are officially recognized right from Manipur princely state when it got merged with Assam. From then these people are considered, and they thought that when it got merged, from then we are losing our identity. Then onwards, Naga and Kuki have raised their prominence and we are losing our rights. That is what the contention they have said. So now here you understand what is the main reason why they want ST status is to protect their particular culture without any violations and all. At the same time, 59% of the population of Manipur, at that time they are 59%, but now it has reduced to almost 40% only. That means there is decline in population because of these people. That is why these people are asking for ST status. But who are opposing the ST status of mighties means Nagas, Zomis and Kukis. So these are opposing to the ST status of mighties. Here you need to know one important thing is this Manipuri language that is spoken by mighty tribe, that is listed under 8th schedule of Indian Constitution. This can be asked in prelims. Okay. So Manipuri language they can ask you, that is because of mighties. Okay. They practice this language, they pronounce this language, and because of this only all this turmoil started. Okay. ST status. So you need to know, remember, one main thing is ST status can be conferred by whom? We have discussed number of times, no? I told you, President of India will notify who will be the ST, but that list will be prepared by Parliament. But how can High Court order that this persons can be granted ST? In that way, how this question started. Under Article 341, 342, Parliament can prepare the list of STs that can be notified by the President. Only these two have authority. Then how Manipur High Court suddenly came into picture and they said ST status can be given to mighties. That is why this all violence started. Okay. This is also seen as judicial overreach. Okay. Then is this demand only means not only this, apart from this, they're asking other things also. Like with respect to opium trade and all, they're asking our rights are getting compromised, nothing much important. In 371 Cs with respect to this Manipur, do remember, okay? Special provisions are protected, right? Then prelims facts you have FSTC. I told you Financial Stability Development Council. So this is very important because this organization is mainly there to ensure financial stability. Okay, financial stability means if you take any decision, suddenly there should not be volatility in the economy. So there should be stability. So to ensure this, all the institutional premiers will be there. Now, for example, IRDA is there with respect to insurance. And you have different regulatory authorities. No, in banking we have RBI. Yes or no? All these are regulatory agencies. No, in different sectors. All these things will be coordinated by FSDC so that there won't be any instability in the economy. That is the main job. So how it was established means by executive order. Same like Niti Aayog. It was also established by executive order only, no? Same way, this is also established by an executive order. Under which ministry? Ministry of Finance, Department of Economic Affairs. And who is the chairman for this FSDC means? Finance Minister. Okay? Along with Finance Minister, different agencies, their particular heads will also be there. Okay? So this is the main job you can see. It was set up in 2010 by an executive order. So what is the main aim is to strengthen financial stability. Okay? This you have to remember. Then parent body, I told you, it will work under Department of Economic Affairs, Ministry of Finance. Secretariat is under Ministry of Economic Affairs. So the chairman is the Finance Minister. This question was asked already. So these are all the members. You can see here different department secretaries will be part of this FSDC. So this can invite experts also in case if it is required. So what is the main function? To identify and address potential threats. What are the threats to financial status of economy? What are the financial sector developments and policies, how to better it, and what are the better regulatory mechanisms we can adopt, and how to promote financial inclusion, how to advise with respect to financial sector matters to the government. All these are the jobs of FSDC. Then Cabinet Committee. Okay. So why this is in news? Because Cabinet Committee on Security headed by the Prime Minister recently has given a green signal for exporting, or you can say sending this BrahMos 200 missiles for another country. Recently, if you have seen, Philippines and all these are buying, no, at the same time, they also have given permission for deploying this BrahMos on warships. BrahMos, you know, it is a cruise missile. First thing you need to know, the difference between ballistic missile and cruise missile. What is the difference? Basic difference. Ballistic missiles will be like this. Yes or no? That means they'll be landed from the land, you can say they'll be reaching the atmosphere, again they'll be coming here. Okay, but cruise missiles like this, they'll be going. Okay, cruise missiles like this, they don't reach the atmosphere again. Okay, within this range only they'll be working. And apart from this, what is the technology? So here if you see, it is taking same like a rocket, no? Yes or no? This is not using anything here, so it has to carry fuel on its own, but here it can take the atmospheric gas as fuel. So these are the basic differences which you need to know. And BrahMos is a supersonic, means more than sound of a speed it can go. So it is a supersonic cruise missile. Do remember this. And this is a joint venture of India and Russia. Brahmaputra river and Moscow you have. Okay, river, another river you have. So first thing here you have to know it about Cabinet Committee on Security. So this is a normally cabinet committees or extra constitutional bodies, means they are not there in the constitution itself. So who has formed these things means for bettering the job of the cabinet, because you know cabinet is itself not there in the constitution. If you have remembered, the word cabinet is not finding its mention in the constitution. But when Article 352 on the national emergency, we were witnessing with emergency, at the time of Indira Gandhi. You know, she has imposed emergency without the written permission of the cabinet. Later on, if you have remembered, 44th Amendment has inserted clause that there should be written hand permission should be there from the cabinet authorizing that national emergency can be imposed. So they have imposed some safeguards. So at that time with 44th Amendment only, this word cabinet is added to the constitution. Till then, we didn't find any mention of the word cabinet in the constitution. Okay. So cabinet means, again, among the council of ministers, some you can say, or powerful ministers will be called as cabinet. So this cabinet extra constitutional committees means in the cabinet also, for example, if you have 7-8 ministries, okay, or 10 ministries, powerful ministries, among them also you will form different groups, 3-4 ministries, one group, and you will reduce the work among them. Okay, so you will try to divide the work so that reduced work burden will be there on the cabinet. That is why we have formed this constitutional cabinet, extra constitutional cabinet committees, you can say. Then what happened? The main job is to reduce the burden. This is what you have to remember. Extra constitution, they don't find any mention. Okay. Then you need to know who will constitute. It is the prerogative of the Prime Minister. Okay. So what functions they have to do, how much is the size, who can be members, everything is a prerogative of the Prime Minister. As there is no mention in the Constitution, there are no rules, right? It is completely the choice of the Prime Minister itself. Okay. Do remember this. Then another important thing is not only cabinet ministers. Most of the times only cabinet ministers will be called for meetings. But sometimes even non-cabinet ministers, like independent charge ministers we have, or MOS also we have, no? Sometimes they can also be called to the meetings of these cabinet committees, but upon request only. But normally they cannot attend. Only when requested they can attend. Okay, that is another provision here you have. Then these are all the committees we have. 8 committees are there. Previously 6 committees are there. 2 recently were added. Okay. You have to remember almost all committees will be headed by the Prime Minister only. In case if Prime Minister is not member of that committee, another minister will head that. Okay. We'll see here. So you can see here appointments committee of the cabinet. Appointment committee means like recommending RBI chairman names or some other important position names will be done by this committee. Then cabinet committee on economic affairs, MSP, fair remunerative prices, economic affairs. Okay. Then you have political affairs. With respect to political things, they'll take decisions. This is also called super cabinet. Okay. Then you have cabinet committee on investment and growth. This was recently added. Okay. Then you have cabinet committee on security. This is what we are discussing now. Cabinet committee on parliamentary affairs. Now this committee is headed by Defence Minister Rajnath Singh. It is not headed by the Prime Minister now. Okay. This is one. And you have this Employment and Skill Development Committee. This is also recently added in 2022 onwards only. Okay. We have Investment and Growth, Employment and Skill Development. These are the 2 new committees formed after this government only. Then you have on accommodation. Accommodation means MPs ki andarki bungalows istaru kada, poor people kada vallu paapam illu levani cheppi accommodation istaru kada Delhi lo, avanni veelu chuskuntaru annamata. Okay. Evaru head chestunarante Ministry of Home Affairs. Okay. Now do remember these 2 committees, Parliamentary Affairs Committee and Accommodation Committee, are not chaired by the Prime Minister. Only these 2 committees. For other committees, every committee, Prime Minister himself is the head. Okay. So you have Appointments Committee already there. Here you can see all the cabinets except these 2 are headed by the Prime Minister. So you can see these are all the members who will be part of Security Cabinets Committee. It is again headed by the Prime Minister. Cabinet Committee on Security means defense related decisions they'll take, and also some appointments you can say for like example National Security Advisor, all these things. Okay, they'll coordinate here. Prime Minister, Defense Minister, Finance Minister, Home Affairs and External Affairs. These ministers will be part of this Cabinet Committee on Security. There is no rigid number. Inni members hai undala name levu. It is again the choice of Prime Minister. Okay, how many members they want. Then IBSC fund. Here you need to know India, Brazil and South Africa. 3 countries, they have contributed something to the fund. What is this fund? You need to know these 3 countries, mainly because these countries from different regions, different continents also, they think that these 3 countries are very underdeveloped, okay, or developing you can say. That is why they have formed as a trilateral. Even with respect to climate change also, they have formed as a coalition, IBSC, okay. So here, in 2004, it was established, mainly these countries, and they promised every year $1 million will be combinedly given from each country. That means $3 million. With this money, they can give to the developing countries in the form of loans and aid. That is what the main job of this fund. So just know the basic things about this. So what they will do with that money means safe drinking water, food security, sustainable development, these things will be taken care. And you have UN Office for South-South Cooperation. Because all these 3 countries are part of Southern Hemisphere only, they try to cooperate in the Southern level. So 5 leadership summits happened so far, and India has hosted the summit in 2021. After that, 2 years presidency will be there normally. Now Brazil has assumed presidency from India. Okay, this is a basic thing you need to know. Then UN escape you have. Okay, this is one body under UN which was established in 1947 only. You can see United Nations Economic Commission for Asia and Pacific. Why we are discussing this? Because this organization has conducted a survey and it found that we have sustainable development goals that we wanted to achieve by 2030. But in the Asia Pacific region, what did they found is we are not able to reach even until 2060 also. because of the level of development, level of economy and all. Whatever the sustainable goals we wanted to achieve by 2030, that even by 2060 also we are not able to achieve all the 17 goals. That is what they have identified. That is why it is a news. Okay. So sustainable development goals, you know how many are there? 17 goals. Okay. So with respect to that, they said, and this is the most inclusive government platform. It is including all the organizations and governments within the Asia Pacific region, and it was formed in 1947. Okay. Mandate is economic and social development. Mainly this is the objective of this organization. It is one of the 5 regional commissions of UN. Okay. Like Asia Pacific, we have African Commission, we have another commission, European Commission, like this, 5 there, and one of this is this UNESCAP. It is headquartered in Bangkok in Thailand. Okay, this is a basic fact about this UNESCAP. Then we have this Munich Security Conference. This is one of the security related conference that happens annually, and this is located in Germany. Okay, so in this context they discussed about in the 6th meeting they discussed mainly about NATO and its presence, because you know Russia and Ukraine war is happening. This is continuing, or you can say this is posing a continuous threat to global security. You know, that is why the main focus of this summit is on NATO. Okay, this is a leading forum with respect to international security. Munich Security means, in terms of security conference, this is the largest conference that take place, and annually you can say this is in Germany. The name can be asked. Okay, so sometimes they're giving regions and news, no, to match. You have to remember Munich is in Germany. So basic thing you know about NATO. NATO is very important this year. Okay, so much of in news you know. Recently 2 countries joined. Which are the 2 countries? Sweden and Finland, no? Yes or no? Now, if Sweden officially joins, it becomes the 32nd member country, right? Okay, so NATO means it was formed in 1949 by Washington Treaty. You need to know, right? So why it was formed? America, North America means USA plus Western European countries, which are developed countries, which are supporting the capitalist ideology of USA, they have formed as a group to protect against Russian invasion. Okay, that is the main objective of NATO. So you have to remember it is also established, also called Washington Treaty, because this is the main treaty which formed this NATO. To counter this, we have Warsaw Pact. Okay, that Warsaw Pact, although it is not operational now, there is another organization in the line of Warsaw Pact by Russia and Eastern European countries to counter NATO, that is Collective Security Treaty Organization, CSTO we call. Okay, do remember this. So this was established in 1949, headquartered in Brussels in Belgium. Okay, so one main thing is Article 5 of the treaty is very important. Article 5 of NATO says, here you have 31 countries, no? In case if any one of the NATO countries is attacked by Russia or any other country, so it will be treated as attack on all other countries. Collective defense mechanism. Okay, that is why this Article 5 is very important. Till now, how many times it was invoked means only once it was invoked. And you know when US was bombarded, no, Washington, you know, 2009 by 11 attacks, you know, no, at that time only once this Article 5 was invoked. Okay, so this is also very important to know. Then we have Rani Chennamma. Just a brief fact about this. Why? Because in the recent time, some organizations, they said they have launched this campaign. Nanu Chennamma means even I am also Rani Chennamma, because they wanted to commemorate 200 years of this women's protest against the British East India Company. Okay, so Kittur Rebellion, that is what you have to remember. So Kittur Rebellion means she is the queen of one particular province or one princely state called Kittur. Okay, so she married one king of the particular area. She had a son. Okay, after the death of the husband, son will become the next king, no? But he doesn't have the own natural son or natural heir, you can say. At that time, to protect his kingdom, he adopted one son. And you know, at that time, British did not allow this adoptions, no? They did not consider them as legal heirs. So doctrine of lapse, even Jhansi also we have. The same thing also is imposed. At that time, Rani Chennamma, she launched this Kittur Rebellion against the British because of doctrine of lapse. Okay, in this context, you need to know this. Kittur Rebellion, she is very famous, and now it is celebrating 200 years of its existence. So they can ask you in one statement. A brief fact is given here, and you need to remember about this. Need not remember all this, but doctrine of lapse is very important. That is why the main rebellion happened. Okay, so you know who invented this? Who introduced this doctrine? Dalhousie. And what are all the states that came under doctrine of lapse? Jhansi, then Udaipur, then Inca. Again, UPSC will ask these type of questions. Doctrine of lapse, subsidiary lens, which are the states which have accepted this? Satara, Jhansi, Udaipur, Sambalpur, we have Nagpur. Like this, different provinces have adopted this policy of doctrine of lapse. Okay. Hyderabad was the first state to accept subsidiary lens. Okay. Do remember this. Last one is Mysore you have. Mysore, you know, after Tipu Sultan's time we have. And we have anti-satellite weapon system. Okay. Why I have included this is Russia is developing anti-satellite weapon system. Okay. So although that is not directly important for us, but in that context, UPSC can ask a question on Indian-based anti-satellite weapon system. If you have remembered, India already demonstrated this particular technology with Mission Shakti, if you have remembered. DRDO has tested this Mission Shakti, you know. A live satellite was targeted by another satellite, anti-satellite. Means in case of any foreign country satellite coming into our airspace, we can target that using this anti-satellite weapon. That is a similar technology we demonstrated with the name Mission Shakti. Okay, a low Earth orbit satellite at the time, which is live in the orbit, it was shooted down with the Indian satellite under anti-mission, or you can say Mission Shakti. That was the name we have given. Same type of technology also they are trying to introduce, Russia. Okay, so already Russia has this. So if India became the fourth country at the time, US, Russia and China, these three countries already have. Along with this, India also joined at that point of time when it demonstrated. But recently Russia is again developing a weapon, anti-satellite weapon you can say, to deliberate and destroy the satellites that already come into their operational orbit. Okay, so two types of energies are involved. Kinetic means basically, remember, physical attack will be there. Directly physical attack means direct attack will be launched and that will be destroyed. But non-kinetic energy based means they'll use some cyber attacks or jammers and they'll try to make the satellite inoperational. In that way, two ways they're trying to operate this. So you have to know there are many countries who have this capability, including India, 4 countries, US, Russia and China. These are the 4 countries which have this type of technology of hitting a active satellite using another weapon. So you need to know what are the issues associated with this is space debris. When you're hitting down, it will automatically create space debris, no? That is one major issue. And under Outer Space Treaty 1967, you're not authorized to do such acts. Okay. Then another main important term you need to know about this space debris is Kessler's syndrome. Okay. Kessler's syndrome is when this particular space debris is becoming a major issue. This is invoked. Okay. So this is a term associated with space debris. Do remember. They can ask this term and this is related to, or this is seen in use with respect to, they can ask. Then last topic we have is small topic, Malta. Okay, where is this country? I didn't give luckily. Malta. Malta recently became 119th country to join International Solar Alliance. Okay, so brief facts about International Solar Alliance. You know, it was launched by India and France in COP21 in Paris 2015. Okay. So, you know, this is mainly to harness solar energy. We wanted to generate 1 gigawatt of solar energy with cooperation between the countries between Tropic of Cancer and Tropic of Capricorn. And $1 trillion also will be generated through this to generate this 1 terawatt, you can say. And you have this countries initially, but now it was open to all UN countries. Okay, do remember this. But so far only 56 countries have ratified and signed this particular thing. 121 prospective members means they signed but they did not ratify. Only 56 have ratified. Okay, they have finally joined. You can say India's role, founding member, and you know ISA headquartered in India itself. So these are the things. First international body which is headquartered in India. And India already have this target of 100 gigawatts as part of 175 gigawatts target from solar energy. Okay, so this is all with respect to this week's current affairs. Okay, although it is a long session again. Thank you for your patience. Although I know that you didn't take anything from my lecture, but still I thank your patience. I can see your faces, I can read your faces too. You people just want to leave as soon as possible when ma'am will stop. Okay? Already, again, it's 2.5 hours. Almost every week I'm crossing half an hour means why I'm again taking extra time is you have to think. Okay. I just can skip after two hours of time. I just can leave some topics, but I'm not doing that. Just try to understand, because I just want to make you people, when you are sitting for 24 or 25, we should cover maximum questions and maximum areas from where potential questions can be framed. That is what the main intention is. So try to be serious, and I'm trying to complete the topics within some time. Even I'm taking extra time also. The areas where I have to focus and where you require some attention, I'm focusing there with some slowness only. I'm not going fast. Okay. Try to be patient and try to cooperate with me also. Okay. So I'm not just here to like brush you up or something, but I just want to train you so that it will be a helpful lecture. That is what the main intention. Okay. See you in the next class. If you have any doubts, you can come.